May I please, Lordship?
Yes.
Well, a criminal petition for listing, my motion, Lordship. Last listed on 29/8/2024,
When it was
Friday.
Court number? Court number 21, senior court.
Senior.
Court number 20.
One bail application was a regular bail application that was rejected earlier by your lordship. In the subsequent bail application, your lordship has called for the CD, since the matter for 6/11. But as your lordship was not available, lordship, stay. May I pray for listing it tomorrow, lordship? Already, lordship, more than 90 days of her lordship.
May it please your lordship, this matter relates to the correction of the order passed by your lordship in Lukadalat. Let the matter be listed on 28. 20.
May please, your lord. So for item number 60 is concerned, this is for impediment. 60.
60.
Can it be taken up at 2, lordship?
Lots of motions are there. I don't know whether it can be. Your item number 60. 60. I don't know. We will try.
My lord, I beg to mention item number 22. My senior is out of session. This may be passed about for day after tomorrow.
Item number 22.
22.
Day after tomorrow. So 24 matter after 1 week. After 1 week. Is it 24 matter after 1 week? After 1 week.
That would be very late, my lord.
Huh?
That would be late, my lord.
24 matter, let it be after 1 week.
Examination item 32, lordship.
32.
32. Sorry, acting for the matter for only for 3 days, lordship. With due consent of the other state, lordship.
With the consent of the student, sir. So we do it. Friday, I'll be leaving. Thursday, I'll come for my but 26 next week. 26.
26.
Because after 3 days again I'm going to Bhopal. In fact, I will not be here. So 26.
26. Obliged. May I please, lordship? Lordship. Lordship, a small pair regarding item 17, lordship. This honorable court direct us to file additional affidavit on last occasion, lordship. We have filed it today, lordship. That may be called for.
Okay.
May I please, lordship? I beg to mention for listing criminal appeal against accused.
Criminal appeal code seven?
It was last.
21. Court number 21. Make a mention in over court number 21.
Lordship, for listing of a criminal petition 1319
You
2020.
also make a mention, senior bench, court number 21.
Lordship, here is
21.
for motion.
Yes, 21. Court number 21, make a mention.
Lordship, another criminal appeal.
Both the matters, you make a mention before court number 21. For motion item 1.
Wait, please, your lordship.
Yes.
Lordship, it is under section 483 of Bharatiya Nyaya 2023. Petitioner behind the bar, lordship, since 17 days, lordship. FIR is page number 9, lordship, relevant portion.
Bharatiya BNS.
Uh, 60 days will be offense minor, 17 days. Let the CTB call for.
Extortion.
Exhaustion. That is one.
Okay, we are calling for the case diary.
Lordship.
Call for the case. Yes, when it can be fixed.
Minors from Bongaigaon. On matter, first week of December, madam. First week of December, any day.
512.
Obliged, lordship.
Item 2. Yes. How many? She is in behind the bar since? As on today, 22 days. And the PS matters, let us call for the case diary. From where it is to come? Lakhimpur?
Bipura.
Bipuria. Can it be on 4th? 4/12. 4th of December. 4/12.
Item 3.
May I please, Your Lord?
Yes.
In this case, the petitioner is behind the bar for last 76 days. The section, Your Lordship, the IPC section has
CBI matters?
CBI matters. About
CBI counsel will be informed. Because I cannot.
names one.
Uh,
Already, Your Lordship, the section already, IPC section already repealed. They are only banning of unregulated depreciation 60 days. Already on coordinate bench have decided on the basis of judgment of the
let
Supreme Court.
the very come. We are going to inform. Yes.
Okay.
All my inform koi dibo
I'm
sister.
informed.
Item 4.
May I please, Your Lordship?
Yes.
Case may be called for moment. And the
It's NDPS matter?
yes. The
Since when he is in custody? It's a commercial.
commercial company.
1/6.
1/6.
So almost 5 months, na?
Yes, my lord.
Almost.
From 1/6,
Yes.
almost 6 months.
Almost.
From 1/6, well, if we count, my lord, because it will be, yes, it will be over by month of November, my lord, because it is from 1/6, my lord. June 6, 7, 8, 9, 10 exact days.
Regarding the CS has been filed or not, or what is the process?
My lord,
When
Friday,
it-
my lord, Friday.
Friday?
Because, I'll see how much he is in custody. I'll calculate.
Friday we are fixing.
Yes, yes.
Friday is
22.
Obliged.
Item 5.
It's a CBI matter, my lord.
May I please, Your Lordship, my senior counsel is on legs, even court number 18. Can the
Uh,
matter be passed over for
But
the
I'm not on them. My lordship may fix this matter along with BA number 3152.
DA
BA number 3152
of
of 2024.
24.
Day after tomorrow. Because other cases are fixed, already fixed, my lord, in court number 3 today itself. So I'm not praying for today, my lord. Day after tomorrow.
Lordship, I haven't taken this one instruction of my senior.
CD, only CD to be called for and to be tagged with that item. My lord, that much.
Okay.
Day after
Lordship,
tomorrow.
day after tomorrow.
Day after.
Saying it because as per him the CD is already available.
Yes, my lord, in court number
CD
3.
may be available in the court, so let it be on Wednesday. Wednesday
Mashallah.
20.
My lord, that
Along with
Along
DA
with-
315.
315 to 20. Case diary may be called for that.
Yes.
Otherwise, it should come
CD
in
be
the
called for and list the matter along with BA 315 of 2020.
I'm obliged. Deeply obliged.
Item 3. May I please, Your Lordship, he's in
Again,
legs.
yes, he is on legs, I think.
He's in court number 18.
Okay then, okay. We are waiting.
Let them come.
Item 6.
May I please, Your Lordship?
Yes.
Lordship, the FIR starts from page number 12. The allegation against the accused person is this, that he was caught red-handed with an amount of 2,700 rupees as bribe. At this, he's arrested, Lordship. At this stage, I humbly pray that the case diary may be called for. Page 12 is the FIR, Lordship.
Is it also a CBI matter or
CID,
CID.
no, Lordship. Vigilance. No,
state of Assam is looking after this one or any?
Officer in ACB police station, Lordship.
It
Anti-corruption.
will be anti-corruption. Case diary, yes, when it can be?
Yes, ma'am. On 10th of December.
10. Very. Okay, yes. Okay, then.
I'm obliged, Lordship.
Item 7.
May I please, Lordship? Lordship, the petitioner is behind the bar for 57 days, Lordship. FIR case 9, Lordship. There is allegation under section 65, 75, 76 to 96, 51 of BNS, Lordship. And also there is POXO, Lordship. So notice may be go, Lordship, and seat may be called for.
So you have come into very, it is almost 87 days.
57 days.
Oh, sorry, 57 days. Notice to go, huh? To respond number 2. Here to process, true. And notice to go to respond number 2. To OC service, to the office of the public prosecutor and the registry. You take steps, huh?
Yes,
because we are calling for the case diary also.
Section 8 is minus 60 days. 57 days. Huh?
So far 65, Lordship.
65, yes,
Yes,
65 is 90 days. No?
90 days.
65 is 90.
Is BNS 65
BNS.
means?
376 AB, Lordship.
Oh, 376 AB.
Rape upon minor, below 12 years, Lordship.
Then why POXO 8 and 17 only?
Lordship, actually, so far
And
allegation is
there
not
may be
accepted,
some other
Lordship.
area, I don't know. But if it is 65, then why not 6 and all?
So far
Maybe they
allegation
do
is not
6 and
attacked, Lordship. So far allegation made in the FIR, Lordship. 65 not attacked, Lordship.
That's why. Below 12, na? But if it is supposed to be 76 AB in place, whatever, 65, then why not 6 is not there? POXO 6? POXO 6 has to be there. Yes.
So 65 not attacked, Lordship.
Stated about 60 years.
16 years, 16.
16.
Yes. 16 years.
Oh, yes. Even if 60 days, 16 years, then also 4 will come. Let us call for the case diary. Try to fix a sort date. Oh, sorry, notice has to go, no?
It is a problem. Maybe third minor. Because notice has to be served, man.
Yes.
Issue notice to you.
Item 8.
Bail or any other mission item asin kya? Baki all are discriminated na. Item 8 is a transfer petition. The petition. 8 is a party here or no? So and so list after 1 week.
Item 9.
After Passover, I'm for the timely.
10.
I may appeal, Lordship.
Yes.
Petitioner filed application for produce the DW, my lord, but that was rejected, my lord. Imperial order is page 26, my lord. Earlier,
Is that
my
page
lord.
26?
Yes, my lord.
That means it is delayed at the stage of DW only.
What happened is this case, please kindly see page 18 below.
80?
18, 1.
1 8. Hmm. Hmm.
The share put up before me. The accused Minhajul Haq is present today. DW, namely Hanif Ali and Mizanur Rahman, are present today. Fixed on 11/6/2024 million. And next million, page 19 million. 11/6/2024 million. Oh,
Acha.
and the
On that day
presiding
also-
officer on leave Miller, and the DW, namely Hanif Ali, is present. Petitioner also present Miller. Subsequently, 2 days Miller, petitioner could not appear Miller. That's why Miller filed adjournment petition. That adjournment petition was rejected. One date Miss Miller, 22nd 7/2024. 2 days Miller, petitioner appeared and adduced.
No, your petition was rejected on 28/8.
28/8.
So on 22/7, you were absent.
Yes.
Mane DWs were absent.
Yes, Miller.
Yes, Kusami anything.
Fine,
Let us
PDF,
leave you.
earlier.
I left, yeah.
Leave it to your lordship.
Mr. A.M. Ahmed, the counsel for the petition, and also heard Mr. MP Kusami, the learned additional people appearing on behalf of said respondent.
Declare no further adjournment.
Yes, this is an application under
Oh,
section
okay.
438, related with section 442 of the BNSS
Condition
against the imprint order dated 28/8/2024, passed by Learned Special Judge Bongaigaon, in special bracket of POXO, case number 16, BNG Bongaigaon of 2019, arising out of Bongaigaon PS case number 344/2019 under section 294/506 IPC, related with section 12 POXO, whereby the petition number 1836/2024, praying for adjournment for the DW was presented. It is submitted by Mr. Ahmed that after closure of after
Page 18. Yes, 18 and 19.
18, na? Accused petitioner. The case was the and thereafter 2-3 adjournments was paid for by the counsel for the accused, and on 14/5/2024 the accused appeared along with DW, namely one Hanif Ali and Mafizur Rahman, but as the presiding officer was on training, the DWs could not be examined, and thereafter also on the next day, that is on 11/6/2024, also the one DW, namely Hanif Ali, was present, but due to as the learned special judge was on leave, the W could not be examined. So, however, the accused petitioner failed to produce on 2 consecutive days, that is on 22/7/2024 and 28/8/2024, prayer for the prayer for adjournment was rejected by the learned special judge, and the case was fixed for argument. It is next prayer submitted by Mr. Ahmed that there was no negligence on the part of the accused petitioner, and due to absence of the learned special judge, the DWs could not be examined. However, he admits that in 3-4 other consecutive dates, the accused could not produce the DW. He further submitted that without any adjournment, the accused will produce the DWs if one more chance is given to the petition. Next prayer, Mr. Goswami, the learned additional PP submitted in this regard, that it is that from the order sheets it's seen that the case is pending at the stage of DW since long and long. However, he submitted that one more chance may be given to the petitioner, which may be considered as a last chance. Next prayer. Considering this submission made by the learned counsel for both sides, all other aspects of the case, and also considering the fact that in two consecutive dates, the DWs were present. However, inconvenience on the part of the learned special judge, that could not be examined. Accordingly, this court is of opinion that one more chance may be given to the present petitioner to produce the DWs before the court. However, it is directed to the petitioner that on the next date of listing, both the DWs should be produced before the court, and no further adjournment will be sought for by the petitioner. With the above observation, allow for reading and the motion stays disposed.
Obliged.
Is there any date fixed?
Next date, next date petitioner will appear before that.
Is it fixed?
Only thing,
Recorded.
Wait for giving one more chance.
Yes.
It may be modified.
Okay, we'll modify it. Take one more chance to modify for it.
Obliged.
No further adjournment will be.
Yes.
May it please, my lord. My lord, the petitioner number herein is the husband of the respondent, my lord. The respondent filed a DV case, my lord, before the SDJM Kokrajhar. That is at page number 16. And that case proceeded ex parte, my lord. If my lord sees the cause title, my lord, page number 16.
Yes.
Wife of so-and-so, resident of village Boniamari, part 2. But this address has been wrongly given. I am a resident of part 1, my lord. So the notice that were also issued, that is at page number 31. Those were also issued in respect of part 2. Angurkota, part 2, village. But I am a resident of part 1. There is a huge distinction, my lord. Why I am stating is this, that thereafter, my lord, in spite of serving the notice at a wrong address, my lord.
You are the resident of?
I am resident of Angurkota, part 1.
Angurkota?
Right. Yes. At page number 16, 16 is, my lord, village Boniamari, part 2. It ought to have been part 1. So the notices were sent in the wrong address, my lord.
Bagri
Bagori Post Office and Police Station, District Kokrajhar. Wife of so-and-so, resident of village Boniamari, page 16, my lord.
Boniamari. Oh, acha. Boniamari.
Yes. Boniamari, part. It is written as part 2.
No. This is the address of the complainant. The agreed open only.
My lord, thereafter, my lord may come to page 17, my lord.
Yes.
Village Angurkota, part 2.
Now, Baniamari part 2 is the address of the complainant.
But my address, my lord, is page 17, part 2 is written, but it ought to have been part 1.
Part 1.
Part 1. Nevertheless, my lord, the suit proceeded ex parte against us, that is the present petitioner, and the judgment was passed at page number 34, my lord. Number 34, judgment was passed on 31/2024, and the operating portion has been present at page number 54, my lord. '53 is the order portion, my lord. 53 is the order portion. I'll just read out paragraph 34, my lord. In view of the ordered above discussions and finding, it is hereby ordered that the respondent is hereby directed to allow the aggrieved to take her street on articles mentioned so and so. Next point, my lord. The respondent number 1 is directed to pay the aggrieved monthly maintenance amount of rupees 8,000 per month. The maintenance amount shall be given by the respondent number 1 from the date of passing of this order. I'll skip the next point. Then point number 5, considering the damages caused to the aggrieved for mental and physical torture, as well as expenses made to prosecute this case by the aggrieved, and also considering the financial capacity of the respondents, respondent number 2 is a serviceman. He's not a serviceman, my lord. He's a teacher in Venture School. His salary is very limited. And the respondent number 1 has a grill shop. There was no evidence, my lord. I am a laborer in the grill shop, my lord. My salary is 9,000. I was asked to pay maintenance of rupees 8,000 and thereby also a compensation amount of rupees 1.5 lakhs. So these amounts were very huge for me, my lord. And I had absolutely no idea, my lord, till the month of April 2024 that an ex parte order has been passed asking me to pay maintenance of rupees 8,000 as well as 1.5 lakhs as compensation amount.
Before passing the ex parte order, most probably there was any report from the process server or that
there was a report, my lord, but that has been managed. That is my contention, my lord. So thereafter, my lord, I came to know about the passing of the order from at page number 56, my lord. This is a notice to the respondent for deposit of the monthly payment along with the area maintenance. The execution case was filed, my lord. So in that case, my lord, when the notice was issued at page 56, Annex 6, I came to know that such and such a judgment dated 31/2024 was passed against us. So thereafter, my lord, I obtained the certified copies. And since the petitioner number 1, he is the son of petitioner number 2 and 3, he was not keeping well, I filed an appeal. So there was a delay of around 100 days in filing the appeal, my lord, under section 29 of the Domestic Violence Act, my lord. So I filed an application under section 5 of the Limitation Act that my lord will find at page number 58. Annex 7. Page 58, my lord. Explanation I had given by para 1 that the appellants are permanent resident of district so-and-so police station, but the respondent complaint is permanent resident. So para 2 that the complainant respondent of the present appeal case also gave false and incorrect address of the appellants in the complaint petition for which the notice of the case was not served upon the appellants, but on the basis of the false report of the police of Bagoribari police station, the case was heard in ex parte against them and passed the final order on 31/2024. Para 3 that before 1st of April 2024, the appellants were quite dark about filing of the case against them. After then, the appellant number 2 obtained a certified copy of the final order and came to know of the instant appeal. So my lord, explanation was given that since I was not aware, we are not aware of the passing of the judgment, and after getting the copy, certified copy, we immediately filed, my lord, with a delay. Then, my lord, against this condemnation application, the impugn order, that my lord will find it page number 84. At page, order dated 39/2024, my lord. Operating portion is at page 85, my lord. The last paragraph. I have gone through the materials on record. My lord, page 85. I have gone through the materials on record. It appears from the petition filed by the appellants for condemnation of delay in filing the appeal that though the appellant's petitioner have contended that the case under DV Act was filed by the respondent giving false and incorrect address of the petitioners for which they did not receive notice of the said case, but they have failed to state as to when and how they got the information about the order passed in the case filed against them by the respondent. They are completely silent about the manner and time of their information about the case and order passed against them. Thus, the petitioner failed to bring on record sufficient cause of delay in filing the appeal. It is settled provision of law that the delay in filing an application should be condoned if it has been sufficiently explained regardless of the length of the delay. However, in instant case, the petitioners had failed to sufficiently explain the cause of delay in filing the appeal. Hence, the petition stands rejected. Accordingly, this case was disposed of, so automatically my appeal was also disposed. Now, my lord, may kindly take, I have already stated, my lord, since the order was passed ex parte, I had no knowledge. Only on the receipt of notice, my lord, that is at page number 56, I came to know about it. But the learned trial court did not, appellate court did not consider all these facts, my lord. In this regard, my lord, there are a number of decisions that, my lord, a liberal view has to be taken in condonation application. Now, a laborer who is, my lord, the earning is around 9,000, if he has to give maintenance of rupees 8,000, my lord, without any evidence to that effect, then it is going to cause serious prejudice to the petitioners, my lord. So at this moment, my lord, what I'm praying is that let the notice go, my lord, let this matter be admitted, records may be called for, my lord. Until then, my lord, judgment may be stayed, my lord. Judgment dated 31/2020.
If it is stayed, then it will be stayed forever.
My lord may fix a date for hearing, my lord. After the appearance, my lord. Otherwise, it will cause serious prejudice, my lord. Because there is not a single evidence to show that, my lord, I am the owner of the grill shop.
On one hand, you are saying that you are a laborer in the grill shop, and on the other hand, you are saying that you are a teacher.
Teacher, my lord, petitioner number 2.
Huh?
Father of the petitioner number 1. He is a teacher, Venture School, my lord. His earning is around 12,000 to 10,000, my lord.
So we are issuing notice at this stage.
My lord.
Stay may not be possible. Let us heard the
Well,
matter.
otherwise, if the execution is proceeding, my lord, if I have to appear and pay, my lord, it is beyond my capability, financial capacity, my lord. That is why I'm asking.
The next date of listing, that may be considered. Otherwise, it will be stayed because you can order of maintenance is also there.
My lord.
Obviously, 1,50,000 or something is compensation amount was there. That may be considered on the next date of listing. At this stage, we are issuing notice only. You file a application before that, we are calling for the case record also. Heard. So, Mr.
Iqbal.
Iqbal, the counsel for the petition. But he this an application. So against the implement judgment and order dated 30/01/2024 passed by Planet SDGN so in case number so directing the petitioner number 1 to pay rupees 8,000 per month as monthly maintenance, along with compensation amount of rupees 1,50,000 to be paid to the petitioner to the respondents. First up, issue notice on the respondents to register DD and as usual process. We are here, respondent is only Asminur, na? So and so. Also call for the case record. The prayer on stay of the further proceeding may be heard on the next date of listing. However, compensation part we are going to stay.
Okay.
However, the payment of compensation of rupees 1,50,000 is stayed till the date of listing, and the stay on and the prayer for stay of the monthly maintenance will be heard and decided on the next date of listing. List accordingly after 4 weeks.
After 4 weeks.
After 4 weeks.
Deeply obliged.
May I please, Your Lordship? My lord, item number 8, my lord, which is already passed over, my lord, due to heavy traffic, my lord, I was at Guwahati Club, my lord.
We are listing it after 1 week only.
My lord, tomorrow is the next date, my lord, for in trial court, my lord. This is a transfer petition only.
Yes, yes, I know.
My lord, can it be taken up, my lord, if Your Lordship permits, my lord?
Yeah, lots of matters are there. Let it be after 1 week only. Manage somehow. Item 12.
Yeah, please, my lord. My lord, may kindly come to page number 48, my lord. Well, miscase was filed, my lord, from the wife under section 125 of CRPC. I am the husband in this case. My lord, may kindly come to page number 51. The point of determination. My lord, upon perusal of the pleading evidence, upon hearing of argument, it has come to before this court to decide the following issues: whether there is reasonable ground for petitioner to live separately from the respondent, which is reasonable and sufficient to make her entitlement for maintenance. This is the first issue which was raised. Second, whether the respondent is liable to maintain the petitioner. If so, in what conduct? So, my lord, if I go with the fact of the case was, in a nutshell, the petitioner has said that there was a demand of dowry, physical and mental harassment which was done to the petitioner. And I am the person who is working in BSF, who is transferred in various part of the state of. Now coming to that, my lord, if that particular portion, whether she was mentally or physically harassed or not, that was never been able to establish by the petitioner side. How I am saying so, my lord? My lord, we come to page number 54, my lord. While deciding these issues, my lord, Honorable Court says that 125 of CRPC has to be seen. They have just elaborated what 125 says. And they have also said subsection 4. If the court finds that no, there is no sufficient ground, if the wife has gone by herself and adultery, we are not onto the adultery. We are saying that she have went by herself. There was no force or physical torture from our side. That was our case. Now, my lord, may come in the same page, paragraph number 12. The marriage between the petitioner and the respondent is an admitted fact. According to the petitioner, after 2 years of marriage, the respondent started to torture her physically and mentally with the instigation of the family members by raising demand of dowry, and on 26/18, the respondent tortured her and drove her out of her matrimonial house as the petitioner could not meet his dowry demand, and she took shelter at the parental house. When she prepared to file case against the respondent under section 125, the respondent took back her to her matrimonial house, but the respondent and his family member did not provide her food, clothes, and other amenities, etc. Well, this is the basic contention. What kind of grievance does she have faced? My lord, may kindly come to page number 56. 56, paragraph number 13, my lord. Though the petitioner was cross-examined in the line that she has not submitted any medical documents to show that the respondent had tortured her physical and that she never went to the police station to report her husband's torture on her. But lodging of an affair is not a precondition for claiming maintenance, and there may be situations that the wife was not required to visit a doctor for any medical treatment for any physical torture on her if she suffered no remarkable injury. So this is the finding. They said if there is, okay. Now, the kind of harassment that a wife may suffer in her matrimonial house for indifference of her husband may be mental as well as physical, and it is not necessary that such harassment should be of such degree as is likely to cause grave mental or physical injury to the wife, as in the case of section 498A. Madam, may kindly come to page number 57.
So everything has been discussed.
No, my lord. I'm coming to that one after discussion. What is the problem that has arisen? Paragraph number 14, the last, if I go from 1, 2, 3, 4, 5, 6. My lord, let me read this entire paragraph. Paragraph number 14. Petitioner is saying that she was subjected to physical as well as the mental harassment at her matrimonial house, and her husband was indifferent and she had to take shelter in her parental house. Respondent is saying that the petitioner was not willing to perform her responsibility towards her mother-in-law, and she herself left her matrimonial house, and she has not tortured even after service of legal notice. She has not returned even after service of legal notice. In such circumstances, it is to look into this court as to whether there is sufficient ground, as the petitioner refused to live with her husband. As already referred above, the respondent is posing vague allegations against the petitioner without valid proof that the petitioner used to go out with male partners in absence. This was given in our WS. We have said that, no, when I was not in my home, I was out of my duty, she used to go away. Now with whom? Male person may be anybody. We are not challenging anything on adultery. Now, when such an allegation comes from the side of the husband without proof, a wife would definitely find it difficult to find comfort with her husband, and such petitioner has a valid reason to refuse to live with her husband. In the complaint, the wife has never stated that my husband has doubted me of going with any other male partner. The contention of the petitioner was I was physically and mentally harassed, and the demand of dowry. Now, while deciding this issue, when this particular fact was not able to be established from the side of the petitioner, this was the interpretational cause by the learned clerk. By interpreting this, then the court came to the finding that no, yes, she has reasonable right to live separately. That is the first one that I'm raising. Now, if I come with issue number 2, while deciding the quantum, I have said that I have 3 dependents: my mother, my 2 brothers. One brother who is having a shop, basically that we say Tamil Panor shop, that is the shop that he's having. One is a tempo driver. This is the contention that they are also dependent on me and I am the eldest one. Now, while deciding this issue, let me come to page number 17. Page number 59, paragraph number 17. If I say your lordship to come to last 2 lines, he has stated in the cross examination that his younger brother Sri Dharen Ray married a girl of the same village, and his other younger brother Sri Brajen Ray has a shop at Chandrapara. From such statement, it is seen that the brothers of the respondent are not dependent of the respondent, and the respondent bears the responsibility to maintain his mother. I may have a shop, Tamil Pan shop, I'm a tempo driver. It doesn't mean that I'm not.
So you will take responsibility of your brother's family.
Yeah, we are in the
and
actually.
You are not going to take responsibility of his wife.
No, I'm not saying that, man.
Then
I'm saying that since quantum has been decided.
Not on your part, your mother is definitely.
Yes.
Your
No,
responsibility.
my lord, what happened is like I have also annexed an
They
affidavit.
both are married.
Yes,
they
yes,
have some independent shops and all. It's rightly discussed.
Madam, my lord, if I may allow to say that while giving the affidavit, I have said the total number of expenditure and the salary that I get. What remains is 21,945. Now, from 21,945 rupees, 8,000 is the amount that I'm saying that it should not be 8,000. It should be a bit lower than that, because merely saying that my brother has a shop and one is a tempo driver, it doesn't make the statement clear that they are not dependent on me. We are living in a joint family now. We are living in a joint
I cannot
family.
say that they're dependent on you. Yes, if financially you may help.
Yes.
That is understood.
Yes.
Being a brother or being a Hari, this is the duty. I
Yes.
won't say. But you cannot say that you have the responsibility of our married brothers.
No, one is married, another is not married.
Responsibility which.
My lord, the boy who is having a shop, he's not married. If I leave the,
dependent.
Yeah, he's a dependent. But the
Independent. He's having a shop. He's a dependent, not dependent.
The earning with a Tamil Bhansha,
Anyway,
we
we are
can.
going to issue notice only at this stage.
My lord, I'm praying for a stay. My lord.
No, not at all. We want 8,000 is there. Let us issue notice first.
No, even
And
if
we
my
are
lord,
calling
if
for
we.
the case record also here.
Okay, ma'am.
Issue notice করে দেব আর same order হবে issue notice to the respondent of case study and also call for the case record. When your next date is fixed for your payment, is it the matter has already come for execution or not yet?
No, it has not gone for execution yet.
Not for execution. Not yet for execution. The order was passed on which date?
17/9/2024.
17/9. After 4 weeks, we are listing it after 4 weeks, or you want any fixed date? Otherwise, it may be delayed. That's why I'm going to
Yes,
give you a
ma'am.
fixed
Yes,
date.
ma'am.
Fixed date after 1 month. After receiving. Pardon? After 4 weeks, only date. The month of December, January, New Year. Obviously, in the New Year, because record has to come. So if it is in New Year, then still fix it. First week. We are fixing it on 8 January.
8 January.
8. We are calling for the case record. Text date
Can it be on 7?
7th?
7, if possible. I oblige.
May I please, Your Lordship?
Yes.
Since the petitions filed by the petitioner to quash or set aside the order passed by the Honorable Principal Judge Family Court Dhuburi by reducing the monthly maintenance from 2,000 to 1,500. Because
3,000
he's-
to 1,500.
Yes, he is only earning only 7,000 per month, and till down to he has only 4,000 in it, and he had an independent mother with him. And if you go to the page number,
3,000 and she has a children or
no,
any
no, no,
children?
issue, no issue, sir, no issue.
Single.
She is qualified husband, and otherwise is in order. We are deprived from the DWs also. So if you go to the page number
Oh, you have been deprived?
19, page number 19, and para number 4. However, the opposite party failed to submit written statement, thus the case proceed for hearing. But written statement in there, page number 8. Written statement already is there. And otherwise, during hearing, the petitioner adduced evidence of examining herself of PW 1 and 2, namely among this and this, in view of the presence being recorded by the opposite party and with a view to consider version while disposal of the case on merit, he was extended to relevant opportunity, if any. But we are not, we are already deprived from the DWs also.
Why
In others,
you have appeared before the court?
no, here
For
I've
production of-
already appeared, and legal sales authorities already we are discussing mutually. But after that, we filed a written statement on 8/7/2024. But there is also Honorable Court already written as that, however, the opposite party failed to submit a written statement. The written statement copy is there also in page number 8.
Was it
We are
accepted by the
deprived
court
also.
or not yet accepted?
In the court also. We submitted in the court.
The WS was accepted by the court.
Accepted. But we are already deprived for the DW also.
See all this.
And otherwise, his other thing is there. In page number 21, the petitioner in her evidence further categorically brought the fact that he does not have any income or any means of support her, whereas the opposite party is a businessman dealing in telecommunication cable network businessman. Actually, is a cable network. This one. What the telecommunication and earns 50,000. And cable network is a person to 50%. And as per month, he has failed to provide any maintenance her. However, no documentary evidence been adduced in respect of the aforesaid business income of the opposite party. But they did not file any documents regarding this one. And another point is there, my lord. She is qualified. In same page number 6, and para number 11, the perusal of the affidavit of disclosure, assets and liabilities petitioner discloses she is graduate, whereas the opposite party is not qualified as she is, as he the opposite party is a SS pass, but he was already SSLC pass. This is the only conflict between regarding this point of the. But even given opportunity to filing DWs in there and the reduced till
there are some grounds that being a qualified, why she is sitting idly, she should do something.
Yes,
like this.
and she is already doing tuition. Also, she earnings more than
Tuition.
him. Yes, tuition also. But she did not disclose this point in here.
Same order. Right? Principal just family court.
Dubri.
Now, see, stay cannot be there because it's only 3,000. That's all. And
Reducing amount will be allowed. It's 1,500. After hearing, if it will be possible to then
after hearing 3,000, you see 3,000. What can I be doing? Anyway, you are made here, na? Yes. MD meeting. So and so. We do. Issue notice corrigible. Against the order of Principal Judge Family Court passed in FC Criminal Case number 06 of 2024, whereby the court has directed the present petitioner to pay rupees 3,000 as monthly allowance, monthly maintenance to the respondent. Issue notice, so and so, call for the case record, list the matter accordingly after 4 weeks. We're calling for the record, you take steps, we are listing it on 4 weeks, after 4 weeks.
Yes, we'll take steps. Highly obliged.
May I plead, Lordship? Your revision against conviction, Your Lordship. The judgment and order passed on 9/9/24 by the Special Judge Jorat, whereby convicting the accused under Section 22B for 3 years and to pay a fine rupees 10,000. Your Lordship.
Under which section?
22B.
22B.
Lordship. during the trial, Your Honor, 6 witnesses were examined, Your Honor. And mostly the 6 out of 6, mostly the witnesses were hostile, and nothing has been proved. Nothing that these witnesses could show that I was involved in this case, Your Honor. There is every possibility of acquitting in this case, Your Honor.
Where's the judgment order? Page 21.
Page 20. Page 19 onwards, the judgment. Six witnesses were examined.
Oh, that's what I'm just saying. That people are believing. Why revision? Can you tell us?
Yeah, we have filed for appeal, but this administrative branch they had objected and said this should be, according to BNS, this should be revision, Your Honor. This is as per this for 3 year conviction, for those 4 conviction of 3 years, we have to go for revision, and accordingly we had filed made it this revision.
Let's see to it.
It has come from the special judgment.
Yes.
As
per
Under which section of BNSS?
Your Lordship, 438, 442, reduction 522. This is revision. For 15th filing was the delegate officer in the 15th was applicable police.
So you're filing under CRPC?
Yes, filing CRPC.
You have filed under CRPC only?
Now it has to be under BNSS anyway. I mean, make it correct this.
I may be allowed to correct. They may pass over. I may be allowed to correct this section. So I filed BNS. I prepared for, but typically, and it is said, Your Honor.
No. Whether the other part, Mr. Goswami, the other part regarding the appeal or division.
About part matter, I have to check because as part matter earlier matter, appeal lies matter.
About the appeal filing, whoever needs the appeal filing.
Completion of a statement.
I'll make it clear.
You see to it.
I'll make it clear, madam.
So can be listed tomorrow or?
Well, yes, to first file a matter of application for correcting this because
No, that what I'm saying, that correction may be there because it is BNS, BSS, all are confused. That apart, appeal revision is to also to be seen. That's why maybe entire matter maybe you just clarify it.
Yes.
And because as per him, it was the direction of the registry to list it as a revision, not as an appeal. Maybe
next week.
Maybe I may not maybe aware of
Yes.
the 3 years maybe there.
3 years.
So in that case, we can fix it either Wednesday or tomorrow. Had some clarification regarding that also. Otherwise, title page has to be corrected. That is wrong. Apart from that, whether revision or is there any confusion? So we're listing it either tomorrow or day after tomorrow.
Thursday, madam.
Thursday, we're trying to list less numbers of matters because Friday. Four matter Thursday going to open.
Thursday or Friday, Wednesday, I have some difficulty in Wednesday, my lord. So can you Friday, my lord? Either way, my lord, Thursday or Friday, my lord. Lordship is there.
I'm a Bhopal.
Lordship, as per your lordship's convenience, my lord. Wednesday.
You have a difficulty on Wednesday.
Wednesday.
Thursday corridor. We are listing it on Thursday. Thursday. So we have any problem on Wednesday, then it is on Thursday. This on Thursday. You also make some clarification, we'll see to it.
Lodge. How much?
50.
NIA. Here, my lord, 1,80,000, my lord, the amount, and ultimately, my lord, learned trial court below, my lord, punished and convicted, my lord, 6 months and 3,60,000 fine, my lord. In default, 4 months. Subsequently, my lord, we filed, my lord, appeal in the lower court below, my lord. First, in the court of the learned session judge, my lord. Learned session judge upheld it, but only, my lord, reducing that, deleting that part of 6 months, my lord, in default, my lord. 6 months.
6 months is deleted. 3,60,000.
Yes, my lord. 3,60,000 in default to undergo simple imprisonment for 4 months. That remains intact, my lord.
Against that you have.
Yes, my lord. Against that, my lord, what is happened, my lord? Already he is arrested on, my lord, 22/10/24. Separate IA file, my lord, by me, my lord. Here in the paragraph, my lord, I have stated in page 8, paragraph 12.
In IA.
IA, my lord. He is behind the bar from, my lord, 22 days. Paragraph 12, page 8. He is a railway employee by profession working as a track maintainer. As such, there is no scope for taking small amount from that complainant for his personal benefit. He rather involved as a guarantor, witness of the brother only. Your petition is only earning person in the family. Moreover, he was all along on bail during the trial as well as proceeding before the appellate court, and he never abused this answer. Thereafter, he has been arrested on and put behind the bar on 22/10/24. So at this stage, your lordship may be pleased to, my lord, stay there, and he may be allowed to go on bail because, my lord, amount whether amount he will try, my lord, otherwise he staying in the custody, my lord.
Otherwise, state is a formal, I think, na? Yeah, issuing notice then.
Yes, yes.
Issue notice, go do that issue.
Bail, IA, my lord, 1097.
Yes, in both the matters, we are staying, issuing notice at present.
But otherwise, he is in jail, my lord. 4 months conviction, my lord. So he may be allowed to go on bail, my lord, putting any condition, because otherwise, my lord, it is a case of, my lord, only 4 months in default, my lord.
So otherwise, imprisonment part is already.
Yes, deleted.
Okay. He took notice issue করে দিব আর আয়ে টু করো এনি মিস্টার গোস্বামীর হার্ড করে দেখাই দিব this application the section 430 of the BNSS. You can define the height problem or suspending the sentence imposed on the present petition by judgment and order dated 9/8/2023 in NICR number 22 of 2022 and section 138 of the NI Act, and also for suspension of order, sentence and order dated 18/9/2024. Passed by Learned, is the Learned Session Judge?
Session Judge, my lord, Bongaigaon.
Session Judge Bongaigaon. But thereby the payment of fine of rupees 3,60,000 was remain intact in default SI for 4 months. Mr. Das, counsel for the petition, I to that by judgment and order dated 19/9/2024, the present petitioner was sentenced to undergo SI for 6 months along with a payment of compensation of rupees 3,60,000. 3,60,000. Payment of rupees 3,60,000. Default in default except for another 4 months. However, at the by judgment and order dated 18/9/2024, the Learned Session Judge has modified the order and sentence. An appellant was sentenced to pay a fine of rupees 3 lakhs, compensation not a fine of rupees 3,60,000 under section 138 of the NI Act in default to undergo SI for 4 months. He further submitted that the accused petitioner is in custody since
22/10/24.
22/10/2024, and accordingly paid for release of the accused petitioner on bail till disposal of the present revision petition, along with a prayer for suspending the sentence imposed on him, so and so. He further submitted that during the entire trial, the accused petitioner was on bail and he never jumped over any condition of the bail. More so, if he is already in custody since last 22 days. 22 days, and if he remains in further custody, the very purpose of filing the present revision petition will become infructuous. Next paragraph. Considering the submission made by the counsel for the petitioner, other aspects of the case, vis-a-vis also considering the fact that so and so, it will allow suspending so and so, and he is allowed to go on bail for rupees 20,000 with one suited like amount to the satisfaction of learned additional or adjudicate. Judicial Magistrate First Class Bongaigaon. Judicial Magistrate to satisfaction, Judicial Magistrate First Class Bongaigaon.
Page 41.
41.
Yes, against the order for PMA.
PNA was?
Wrong. That is different case.
Otherwise, so he is in custody now.
Yes. A railway employee already suspended permanent.
And if he remains further, suppose for 4 months, then his this will go and track his 15. Dispose kori or it would notice kori call for request.
Register
To the satisfaction of so and so, and you also submit the bail order before us after compliance.
May it please your lordship. Lordship, here we have come challenging two Zimma orders, my lord. The orders rejecting the custody of our phones and two SIM cards, my lord.
Phone and SIM card.
Phone and SIM cards, my lord. We had applied twice before the learned magistrate, but on both occasions it was rejected on the ground that the FSL report of the phone is still pending. But there was nothing about the SIM card. My lord, if your lordship kindly...
And SIM card.
My lord. Actually, the problem, the petitioner is a lawyer, my lord, and we need the SIM card especially because to contact the clients, we're not even able to inform the dates. So another option for us is to take out a new SIM card of the same number that will block the previous SIM card. But my lord, we have not done that because it may have some repercussions. The investigating authority may say that we're trying to tamper with the evidence in some form. Although, my lord, the FSL, the phone, we have no such urgency with respect to the phone, even if the FSL report is awaited in that case, but we need the SIM card, my lord, one of the SIM cards.
So the SIM card will be
along with
the
part
phone,
of page 27 is the last order, madam.
yes, page.
Page 27.
Yes.
If I may read the second last paragraph. It is reported that mobile phone mentioned in Zimma petition filed by Sri Bulbul Hussain was seized by MR number 47/2024. It is further stated that the seized mobile phone is required for further investigation of the case. It is further stated that presently in regard to the seized mobile expert opinion is yet to be obtained from the CFSL. Hence, IO has prayed not to release the Zimma article for the interest of
Otherwise, it is a case of what nature of case?
My lord, here...
No, what is the nature of case?
The FIR is at page number 18, my lord. Actually, what happened, there was a Facebook post.
Yes.
There was a Facebook post which was slightly critical, my lord, criticizing certain political statements, my lord. So, in repercussion, this FIR was lodged. And the allegations were blown absolutely out of proportion, my lord. These are... and
We are calling for a report at that.
And
do you have any information regarding the CFSL report?
No, my
whether
lord.
that has been obtained by the IO till date? No.
Not yet. But we were released on bail also. The learned CJM was pleased to release us on bail within 7 days, my lord, considering the materials in the CD, my lord. So I have annexed the bail order also. So
because now it is a case of this, I mean, the information technology matter, so IT Act under.
May be required, but the SIM will only provide the case call detail records, my lord. Because SIM won't contain information, my lord, other than the details of the calls. So that can be obtained otherwise also.
At this stage, you cannot say this. The requirement of SIM may also be there, I think, for the investigation purpose or before obtaining any CFSL report from the laboratory. That may be awaited. That may be, I mean. So we are calling for the report first. See the most report from the I regarding the Zimma options. Again, I details. Hard code. So it is not hard code report. Yes, can be any date.
After 10 days, madam. Or 28.
28/11. Oh, 28/11.
Much obliged.
17 affidavit. Your affidavit has come.
Okay, Parag, it has come.
Yes.
Lordship, the small prayer before Lordship. Thing is that, my lord, in 2022, we have lodged an FIR. Every material has been collected because only one piece of document that has been sent to the FSL, my lord. That report could not become, therefore, on that ground, my lord, the charge sheet and final report has not been submitted. Now, my lord, the facts of the case in nutshell is what, my lord? The petitioner, my lord, is a permanent resident of Guwahati. My lord, they have a paternal property, huge property in Guwahati, my lord. Now, on account of, my lord, some job prospective, my lord, now he has been transferred to Canada, my lord. Now, while he was Canada with his mother, the property which is joint property, in 2017, my lord, behind their back, the land mafias in Guwahati, my lord, 3 bighas of big land, my lord, transacted and prepared a, my lord, deed of, my lord, agreement, my lord. Now, while this matter was brought to our notice in 2022, because they are happening to take over the position of so-and-so, in 2022, my lord, we lodge an FIR. In regard to that lodge an FIR, my lord, that we have been called for, we have adduced our evidences, recording everything. The surprising element is what, my lord, that in 2019, when this agreement was executed, at that point of time, the mother and the petitioner itself were in Canada, my lord. Because, my lord, without passport, nobody can travel, my lord. This has been, my lord, reflected in the status report itself. Now, 9/4/2024, a status report was submitted before the learned CGM, my lord. That reflects, my lord, in page 29, my lord. But this is the status report 19/4/2024, and the operative part, my lord, just take a turn to next page 30. The middle line, my lord, start from besides. Middle line, 1, 3, 4, 6 line, my lord. Besides the LSD was shown executed on dated 7/12/2019, on which both of them were in Canada and not in India, as they had concluded their previous visit to November 2019 from the stamp endorsement made in their respective passport. Since they did not make any agreement with anyone, not to speak of the purpose purchaser Sri Kandar Pakarita and Sri Jaydev Bora, whose name figured in the LS deed of agreement for sale and who are stranger to them, it appears that the same deed of agreement is a fraudulent document prepared by the unscrupulous fraudsters by impersonating them and forging them and his mother's signature. This is a clear-cut, my lord, clinching evidence that has been collected by the IO. Now, let's just take a turn page 31 where we have been aggrieved. Further, the specific signature of the complainant and the accused person have been taken in presence of GOs and sent to the Director of Forensic Laboratory Kahli Para for examination along with duplicate agreement copy of the sale deed, which was received with FIR copy as original agreement copy of the sale deed did not produce by Srimati Pratiksha Sharma till date. But the DFL informed that the original agreement copy of the deed is required for examination. Therefore, the case is pending due to the non-receipt of the FSL report, as DFSL yet to complete the examination of special signature due to lack of original agreement copy of the sale deed. Now, let's see, the legal question is that. Well, legal question is that it is settled position of law by the Supreme Court in different Katrina judgment says that the FSL report is not a sign of non-mallet to submit the charge sheet process. Not a person to that, just have a look that our honorable Guwahati High Court event in consonance with my lord police administration took a decision. Just reflect that in page 5, last paragraph. Page 5, last paragraph. May I read, madam? Honorable the Chief Justice suggested that the IO should make all endeavor to submit charge sheet within the statutory time, and even in case where the investigation required to be continued beyond the statutory period, the IO should submit initial charge sheet to be followed by supplement final charge sheet if necessary, so that the accused person cannot take the undue advantage of securing bail or technical ground. Honorable
This
Chief
status
Justice,
report was called for on 19/4/2024.
my lord.
Why it is overlapping? 24 is
My lord.
in page number 21.
My lord,
24 is overlapping. Why?
My lord, if any mistake, I am extremely sorry, let me, my lord. 19/4 and
Page number 29.
29, 19/4, my lord, and that 32 pages of 19/4, my lord.
No, dated 19/4. Was it? It's not. Yes, 24 is slightly overwriting. Why? Type copy.
Now, page 5 clearly indicates that initial charge sheet to be submitted so that the accused will not take advantage of.
Yes, Gusami, anything to say? Let us. Yes. See. Non-submission of the charge sheet, yes. Yes.
Issue any direction, my lord.
And if that be the position, most probably he could have filed and
Yes.
yes, read jurisdiction now. Yes. 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 It's not
My lord,
proper for
my lord, I know this position.
that,
So the legal point is that, my lord.
no, legal point is there, but we cannot the direction of this nature.
Quite right. I support that. Question is that I am submitting this element. In in that judgment says that in case of no risking of the FSL report, my lord, in that situation, how to deal with the situation and what direction can be passed by this honorable court, my lord. My lord, I have enclosed the Supreme Court judgment in likewise
No,
situation.
no, it's okay, but
Now, lordship, thing is that that mafia is now disturbing that man old lady, my lord. The question is that because that charge has not been submitted, the situation is
why
being.
you may file a petition before the proper forum. In fact,
My lord, thing is that, my lord, nothing is happening, my lord. That we are not totally helpless, my lord. That's why we have
no,
to
no,
report
no,
this.
no. Maybe direction, maybe.
My lord, everything we have done, my lord. Believe me, by 2022, we are running from there to there, there to there, my lord.
But here in this instant case, what kind of, because the status report is at best we can call for a status report. That apart, I think it should not.
Submitted because the decision of the honorable Guwahati, another high court was there on the basis of the material which has been collected. If IO is sufficient to believe that this is the prima facie material which is supposed to be the part of charge sheet
No,
of
that direction, whether this court can direct this, that direction.
Lordship,
Where are the
kindly,
direction part?
Lordship fixes after 2 weeks, I will satisfy that whether this possibility
Or
there.
before the read, I think would be proper.
Well,
if there is any such kind of direction you need.
If they have any grievance against the IO, that is the pure grievance against the IO.
Yes, obviously, yes.
Whether they have approached against the IO before any superior authority.
We have approached, my lord. Believe us, lordship. Thing is that even IO is not responsible. I tell you that there is no grievance against IO is now holding on what point that
Now,
because
as per you, would the higher authorities for, interrupting these things?
no, not
filing
required,
the
not
charges?
not required. Why, my lord? The IO is not responsible. IO's views is that since I have not received the FSL report, therefore I could not submit the charges. That is his. That position is now lying there.
Yes.
Now this position has to be clarified. This honorable court. That under this situation, how this circumstance has to be dealt with, my lord. Proceed fix after 2 weeks, I will satisfy, my lord.
Okay. Please stop.
We are not blaming to the IO, my lord. It's a legal crisis. Even Supreme Court, my lord, in such a situation, directed within 3 months, the CBI was directed to submit the charge sheet, my lord. Therefore, it is not, my lord, that vacuum is there.
No, to some reason whether that direction can be given
But
by
I will
this court,
satisfy.
this forum. That is
I will
the
try
one.
to satisfy after 2 weeks, my lord.
Please stop.
May I please, Your Lordship? My Lordship, in this criminal petition, I have challenged the charge sheet dated 7/4/2024. But my Lord, earlier I have challenged the FIR by filing a criminal petition number, my Lordship, criminal petition number 146/2024. It is at present pending, my Lordship. During pendency of that criminal petition, this charge sheet has been filed. Charge sheet I have annexed.
No, one
on-
criminal petition is still pending.
Yes, I have challenged the FIR in that criminal petition.
In that case, I think in the petition itself, by filing an additional affidavit on your prayer, you can pay for the.
Can be taken together.
Or can be taken together. Yes, that
This
can.
petition can be tagged with that petition also, my Lordship.
Yes, that can be. That can be.
Criminal
Is
petition.
this is still pending for?
Yes, yes.
Most probably there was no order of any stay and all. That's
No,
why.
I have not stayed.
Heard so and so dissent petition under section 528 of BNSS for quashing of the influence charge sheet number 179 of 2023, 420, 468, 471 IPC arising out of for PS case number 1158 of 2023 dated 23/6/2024. Sorry, 23 under section 420, 468, 471 IPC. It is further submitted by the other petition number. Can you tell us?
156/2024.
24. Submitted by Mr. So and so that another criminal petition is still pending for disposal, wherein the prayer for washing of the FIR was made being numbered as criminal petition number 156 of 2024. But during the pendency of the said criminal petition, this charge sheet has already been filed. Accordingly, he prayed to tag the present criminal petition along with 156 of 2024. List the present petition along with 156 of 2024, also issue notice to the respondent number 2 to raise to the DNS process. And you may make a call for the scan copy also.
Yes.
Scan copy of DLCR from the consent code search. List accordingly after 4 weeks. So we are calling for the case record also. We are tagging this one with 156 of 2024.
Please, Lordship. 528 application for the settings and quashing, my lord. Petitioner is a husband and S1 2 is a wife, my lord. The petitioner got married in the year of 2013, my lord. After that, my lord, out of their outlook, my lord, one son was born, my lord. Now, my lord, 9 years old.
Petitioner
Petitioner
number?
1, my lord. Petitioner 1. Petitioner is a husband and S1 2 is a wife, my lord.
Achha.
My lord, the marriage was solemn, my lord, 2013. Out of their outlook, my lord, one son was, my lord, was born, my lord. Now, my lord, he says 9 years, my lord. But in the year of 2015, my lord, S1 2 left the matrimonial house, my lord. After that, my lord, she filed the maintenance case, my lord, under 155 CRBC, my lord. Kindly see the page number 21, my lord. That is order passed by the learned Principal of Family Court, Barpeta. Page number 21, my lord.
Page number?
Page number 21, my lord.
Yes.
My lord,
125.
my lord, order passed by the learned Principal Judge, Barpeta, my lord, Family Court, my lord. May I read, my lord, order? Para number 13, my lord. In result, my lord, the petition under section 125 CRPC filed by the first party is allowed on contest. The second party is hereby directed to pay the maintenance allowance at the rate of 1,200 only per month for first party and allowance 800 for the per month for the minor son. So the maintenance allowance 2,000 paid by the second party for first party and minor son with effect from file this petition.
Now it got enhanced.
Petitioner
It's enhanced now.
Yes. Petitioner was paying the monthly amount, my lord, with effect from this petition, my lord. There is no objection, no any problem, my lord. After that, my lord, Petitioner 2, my lord, again file enhancement petition, my lord. Kindly see the page number 26. For enhancement petition, my lord, increasing the monthly amount, my lord. Page number 26. Para number 7, my lord. Para number 7, my lord. Considering the all above aspect, I found and hold that there is a chance for circumstances in favor of the petitioner. In a result, the petitioner under 127 CRPC filed with the petitioner is allowed enhancing her maintenance allowance from rupees 1,200 to 1,500 and 800 to 1,000 as a total 2,500, my lord, with effect from the date of the passing this order. It is also correct. There is no objection, my lord. Petitioner is regularly paying the maintenance for wife and his son. Now, my lord, again, my lord, the Petitioner 2, my lord, filed again a case, miscase, my lord, for enhanced petition, my lord. Kindly the page number 35, my lord. This is third time, my lord. Page number 35, my lord. This is the impeachment order, my lord. Page number 35, para number 11, order, my lord. Page number 35, para number 11, order, my lord. In the result, the maintenance allowance payable for the first party is enhanced to 1,500 to 2,500 for per month of his wife, and my lord, for son, my lord, the 1,000 to 2,000 for son. It is direct to the second party to shall pay the enhanced maintenance allowance at the rate of 2,500 per month for first party and last page, my lord, 36 rupees 2,000 per month for her son, my lord, with effect from date of filing this case, my lord. This is the main problem, my lord. If we take this filing this case, my lord, then we have to go back to 2015, my lord. That is the main problem, my lord. Regarding payment, I have no any objection, my lord.
Okay.
Now the last order, as per order, my lord, total amount is payable by 4,500. Regarding payment, I have no objection. But it should be effect from this passing this order. This order passed 21 September 2024, my lord. My prayer is that, my lord, this order should be effect 21 September 2024. My lord, kindly issue notice, and my lord, in the meantime, stay this impugned order, my lord, dated 21 September 2024.
Heard Mr. Sweat so query. This is an excellent so query. Issue notice query. Also call for the scan copy of the case record. Next one. Order it is submitted by Mr. Rahman that he has no objection in he was paying the regular maintenance regularly from the date of initial order, and also was paying regularly enhanced amount of rupees 2,500 since the date of order as directed by the learned principal judge. But while order dated 21st September 2024, that is the impugned order, the petitioner was directed to pay the enhanced amount of maintenance from the date of filing of this case, which and against that particular order only the present division petition has been filed, and hence prayed for stay of the order dated 21 September 2024 till the disposal of the present division petition. Next para, considering the submission made by the Learned Counsel for petitioner, let the order dated 21 September 2024 be stayed till next date of listing. However, the petitioner will pay the monthly allowance regularly as directed earlier. First, so list the matter accordingly after 4 weeks. So that present particular petition whereby you are asked to pay
2,500 per month. As for the second time order,
that is stayed. Okay.
that is self-condition order. I have no objection. I am paying and I will be paid. No problem. This order will be stayed.
That's what I'm saying. That's what order is stayed. Till the next date of listing. Next date of listing.
This is a revision against a Zimma order. My lord, what has happened in this case, one person named Vivek Phukan, my lord, is the informant of the case. He is a registered owner of a Toyota Fortuner vehicle. Now, Vivek Phukan, he enters into an agreement with one Lohit Brahma that I'll transfer the vehicle to you, conditional transfer, that you keep on paying the EMIs. So accordingly, he gives the vehicle to Lohit Brahma, and on condition that Lohit Brahma will keep on paying the EMI. There was also another condition that Lohit Brahma will not transfer the vehicle to any other person without the consent of Vivek Phukan. Now, after 8 or 9 months, Lohit Brahma keeps on default. He is unable to pay the EMI. Lohit Brahma now executes an agreement with me, saying that this is the vehicle, I am giving you the vehicle, you keep on paying the EMI. I have already paid the remaining portion of the EMI. Now, subsequently, I go and when I try to pay the EMI, I found out that there is already an outstanding amount which has not been paid. In the meantime, I have already paid him 15,80,000 rupees for the vehicle. So I tell him, I confront him that I have already paid you the money and there is already outstanding amount. So you take back the vehicle and give me my money back. He issues me a check. Check gets bounced. He pays me 1 lakh rupees in cash and the check is issued. Check gets bounced, my lord. Now in the meantime, Vivek Phukan, since bank contacts him that the loan has not been paid, so he files an FIR against Lohit Brahma saying that I have given him a vehicle and he has done this and this. And he then files a Zimma petition before the learned magistrate. Since he is Vivek Phukan, original registered owner. Now the learned magistrate calls for a report from the IO. IO says that vehicle is not required for investigation. So Zimma of the vehicle is given to Vivek Phukan. Now what the learned magistrate did not do was that the FIR was very specific. The FIR said that I have given the vehicle to Lohit Brahma. So Lohit Brahma should have been heard. And if Lohit Brahma had been heard, then my contention would also have come into the picture. Since I have also paid money, I have also paid 15 lakh rupees. Now, my only submission before this honorable court is that when the order was passed, it was passed without hearing me or without hearing Lohit Brahma, my lord. That is why we have filed this revision petition challenging the impugned order. The impugned order, my lord, is at page 25.
Yes.
Page 25, my lord. So today is fixed for Zimma report. Learned counsel of the petitioner is present and has filed his learned APP is also present. IO has submitted a report where he stated that the vehicle bearing such and such was seized in connection with the case, and the registered owner of the vehicle is Vivek Fukan. That is not in dispute, my lord. The IO further stated that the vehicle is not required for further investigation of the case. Then, my lord, relying on Sundar Bhai, my lord, the pair is allowed subject to execution of bond of rupees 40 lakhs. Now, since the FIR specifically discloses about Lohit Brahma, what the learned magistrate should have done was also issued a notice to Lohit Brahma. Since, if my lord will kindly come to the FIR, page 21. Sorry, page 20, not 21. Page.
Yes, it's 21.
21 is another FIR lodged by me. Page 14, madam. Page 14, madam. Your lordship has page 14? Most respectfully, I beg to state that I, Vivek Fukan, such and such, sold my Toyota Fortuner wide registration number on condition to Lohit Brahma due to dire need of money. He further sold the vehicle to the under the same condition to Pogola doctor, husband of such and such. That Pogola doctor is referring to me, my lord. The prevalent condition under the two previous sale was that if the vehicle was to be sold to another customer, written approval of the original owner was necessary, as the vehicle was still registered under my name. So now, whatever be the infractions of law, my lord, this part has been brought to the notice by filing this FIR that vehicle was sold to Lohit Brahma, subsequently sold to one Pogola doctor, whoever that may be, my lord. So when this impugned order was passed, my lord, it was incumbent upon the magistrate that these two persons should have been heard. That was not done. So that is why we are challenging this order. But at this stage, let notice go, my lord. Let Vivek Fukan come as well as Lohit Brahma come, my lord. LCR may also be called for. And just one submission, the order already says that the vehicle may not be disposed of without prior permission of the court. But since already our court has passed an order without hearing me, so if prior permission is accorded, we will not know, my lord. So in any case, just an observation that if any such prior permission is sought by Vivek Fukan, then we may be heard.
Permission for?
If Vivek Fukan, because the condition is that if Vivek Fukan sells the vehicle, he may take prior permission from the court. Since court has already passed an order in our absence, at least if any such prior permission is made, notices may be issued to us, madam. We may be heard.
This order was passed, madam.
Yes.
Yes. Madam, I'm just reading one paragraph, madam. Then, sir, it is learned from the registration certificate and scrutiny to traffic was that the aforesaid vehicle was registered in the name of Vivek Fukan, my lord. So, my lord, the order was rightly passed in favor of Vivek Fukan because he is the registered owner as on date, my lord. Now, lordship, he sold the vehicle to another person. That person sold to this petitioner, my lord. If that is not, vehicle has not been transferred, my lord. So, at this time, my lord, let the notice be issued, my lord.
Well, that is
let
my
the opposite
submission.
party appear, my lord.
That is my submission, my lord. Just this, he may not sell the vehicle, but that is the only.
Heard Mr. S. Thomas, you learned counsel for the petition, and also heard Mr. P.S. Law for R.J. Borga, the counsel for the learned administrative so this is an application under section 528 of the BNSS, read with Article 227 of the Constitution of India for quashing of the impugned order dated 7/8/2024 passed by the learned Special Judicial Magistrate First Class Kamrup M in Dispur case number 677 of 2024, which is registered under section 406, 420, 468 IPC. Whereby the learned magistrate has granted Jurma of the vehicle to the opposite party number 2 without hearing the petition. Issue notice issue notice to the respondent number 2 and private respondent number 2 and 3 to registered AD and as usual process. No formal notice is required to be served on state respondent number 1. However, the requisite copy of the petition be furnished to the students. Also call for the scanned copy of the LCR. It's a transited matter, Nikki. Ongoing. CTB call for. However, considering the submission made by the learned counsel for the petitioner, the the original owner of the vehicle, that is the respondent number 2, is so no, if some considering so and so, the respondent number 2, the original registered owner of the vehicle, is
My lord, may make it that the Zimma order shall be subject to the outcome of the criminal petition, my lord. That will also do, my lord.
no, there is already a Jima order.
The Zimma order, my lord. Yes, my lord. The only thing with the the origin owner will not sell the vehicle as directed by the learned as is learned Mr. First class by passing at the time of passing the order of Jimma. However, the court is also hereby asked to issue notice on the present petitioner if any prayer is made by the petitioner if any prayer is made by the respondent number 2 for selling, selling or disposing of
selling or disposing of the vehicle in question. This is the matter accordingly after 4 weeks.
4 weeks, मतलब देता है, मतलब date will be
Date. Okay. CD will be called. They can be on 8 January. 8th of January. Okay. If you want.
Lordship. Here the petitioner, Lordship, is aggrieved by the order dated 24/9/2024, Lordship. That is as Annexer F, page number 35, Lordship. Here the page number 35, Lordship. Here the petitioner has prayed for DNA test, Lordship, because the case is under POSCO and 376.
Your prayer for DNA test was rejected.
Rejected.
Private respondent is 1, 3, Monus Tau.
2, Lordship. Monus Tau.
Yes.
Till then, trial may be stayed because next date is fixed.
Yes, next date is?
Next date is fixed on tomorrow, Lordship.
For?
SD, Lordship. Statement
Yeah, for
difference.
SD. After SD also you can.
Statement difference.
Statement difference. After
Already the
statement difference,
evidence-
your prayer for recording of if there is any prayer for the DW also, that will be heard. So it's not, stay cannot be there in a POXO case.
Because the trial is almost over, man.
Most of obviously, if DNA prayer for DNA is rejected, that has to be seen. But on what condition it has been rejected?
At least
Otherwise-
the notice go on.
Yes, we are going to issue notice on that. But so and so and this is an application under 528 তাকে কি লিখি দিব GSF দেখিছে ন তাতে লিখি দিব issue notice কৰি দিব also call for the you need the scan copy.
So copy record is needed.
Scan copy will be required.
Maybe call for Manu, but before the Manu, there's the opposite party here, man. If required, Manu, then.
If then required, then it will be again delayed.
Lordship, it will be delayed, Lordship.
Then Manu skin to be
Scan copy will be also called for along with the present status of the case. They're calling for the status also. Let your SD be recorded. If it is recorded tomorrow, then you can pray for time, and in the meantime, let them appear. We'll see it. After 4 weeks.
Lordship, date may be fixed, Lordship, because
you want any fixed date?
Yes,
it will be in the month of January only. 9th of January. Ninth of January, therefore, we better to give it in December only, I think. Na?
Yes, Lordship. Short date
Yes.
may be provided, Lordship.
18th of December. December. Short word.
Oblige, Your Lordship.
ইমান একেলগে ইমান মোচনত ইমান কিমান পেটিশ্যন ৰাখে নেকি? ৰাখক, কিন্তু ইমান ৰাখিলে প্ৰব্লেম হয় বুলি তাতে নহ'ব আজি সেইটোৱে কথা।
My please, Lordship. This petition, Your Lordship, filed by the petitioners for Jimma, Your Lordship. In this case, Your Lordship, page Your Lordship, turn to the page 30. This is the reject order of Jimma, Your Lordship, filed by the petitioners. 31 page, Your Lordship, only in Your Lordship, seriousness of the allegation that Jimma petition has been rejected by the learned court below, Your Lordship. In this case, Your Lordship, only
Jimma of what Jimma?
Jimma of Your Lordship vehicle and sum of vehicle and your sum of mobile phone, one mobile phone, and Your Lordship one ATM card of Punjab National Bank. That if you find, I have enclosed documents, Your Lordship.
Your petition was not only rejected for seriousness, but also most probably bill was there that from the illicit proceeds or the sale proceeds
Your Lordship,
or whatever.
two case alias was registered against the petitioner, Your Lordship. That case has been getting bail, Your Lordship. That I have enclosed that bail order, Your Lordship. 25 first bail order, Your Lordship.
Yes, obviously.
And another, Your Lordship, 27. So in this case, the petitioner has already been granted bail, Your Lordship. So perhaps the investigation almost completed, Your Lordship. That is the registered owner of his vehicle, Your Lordship. I have enclosed the registration certificate that you find, page number 12.
He is a registered owner as well as one of the accused.
Accused. And he's under bail, Your Lordship. So as per allegation, theft, regarding theft, 303 subclause 2, FIR page, Your Lordship, find 17. 17 page FIR. This is the first FIR. And in this case, the Hatiga police station are conducting a naga checking in front of Hatiga police station. And Your Lordship, at that time, one Scorpio vehicle was coming from Bhetapara side, and in the meantime intercepted that vehicle. And some of articles of electronic device, such as power materials, has been recovered from this vehicle. And accordingly, he has been arrested. And along with, there are two accused person was arrested by the Hatiga police. And in the meantime, this petitioner was approached before the Elaka magistrate, and accordingly, Elaka magistrate has been granted the bail that you find page number 25. And at that time, the another case, sworn arrest, was filed by the another IO of the Hatiga police station.
Similar kind of
situation. So in this case, he being an registered owner of this vehicle, as well as all documents I have enclosed. So Lordship, any condition may be imposed, Your Lordship.
Yes.
Pursuant to our division bench judgment, my lord. During investigation, my lord, the vehicle, my lord.
Already released on bail, Your Lordship.
Granting bail is different, my lord. But during investigation, my
Your
lord.
Lordship. Say another judgment, Your Lordship, a best court judgment.
Notice be issued, and Lordship may call for the, my lord, case diary.
Case diary along with the report of the IO, I think.
Yes. Short date may be given, Your Lordship. 29/8/2024.
IO report.
The vehicle was laying in the
and also call for the case diary.
short date, Your Lordship. At the campus of Hatiga police station, Your Lordship.
Yes, Bora, when can it be given?
25 or 28 this month.
So that will be 3rd of December.
No, Lordship. So long date, Your Lordship.
So today,
Hatiga is the very near Your Lordship. This is the Kamrup district.
Report,
Report, Your Lordship.
Report, my lord, already report received, my lord, that has been, my lord, effected by order in 411, my lord. My lord, in 411, that report was exist, my lord.
Supreme Court.
So I am just fixing, my lord, 3rd of December. So that within 1 month, my lord, there may be some
development will be taken. Okay, we're
Short
fixing
date.
it on 3rd of December.
Before November month, this November month, kindly fix for report, Your Lordship. Only report, Your Lordship. Otherwise, in the 29/8/2024, the vehicle is laying in the
29 is 29. So okay, then we're 29/11 we are making it. 29/11. For report as well as we can spell the CD also if there is any progress in that. investigation progress, we can see.
Oblige.
29, na? Notice issue kori dibo, beshi likhibo nalage, notice issue. Call for the report and also call for the case diary 29/11.
24.
Yes. Two I cannot say because lots of matters have been already there.
24.
25.
May I please, Lordship? Lordship, may kindly adjourn the matter for today, Lordship. Lordship, counsel for the petitioner is unable to appear today due to his personal difficulty. Lordship, may kindly fix the matter tomorrow or day after tomorrow.
After one.
Obliged.
26.
Basically, on full ground, Lordship, it has been registered under 21B, Lordship, of NDBS Act. It comes, it will be 21A, Lordship. The actual weight of the contraband is A, Lordship. And second ground, Lordship, that no recovery from this portion. And third ground is that his wife was arrested, so he was looking, police is looking for him.
Say AB, and
AB,
the case we are
Lordship.
better to call for a case diary. Case diary, yes, the Boruaban can be called for.
From Jalupuri case, madam.
Yes.
28, madam.
28.
28.
Much obliged, Your Lordship, much obliged.
Call for the case diary.
27.
Wait, please, Your Lordship. Lordship, this is an anticipated bail application, Lordship. We are FIR on page 17, Lordship. This is the case, Lordship, which I think, Lordship, in this village, Lordship. Almost, Lordship, 27% was named in the FIR, Lordship. Out of that, here 21% is approached this court for anticipatory bail, Lordship. What happened in this case, Lordship, when the informant father was practicing, Lordship, black magic, Lordship. Practicing black magic, that's why, Lordship, during that time, Lordship, one of the villager has been died for his wrong treatment. Now, there is a, Lordship, Lordship, there is a anger amongst the villagers, Lordship. They want to ousted this person from the village, Lordship. Now there is a allegation that is reflected on page 18, Lordship. Now one more thing, Lordship, the co-accused, one co-accused, Lordship, that was arrested, Lordship. That case is pending today, listed before the Honorable Court number 3, Lordship, BA 3326/24. Case diary is lying there, Lordship.
BA
3326/24. That is regular bail, Lordship. Case diary is lying there, Lordship. So may I pray, Lordship, this item can be taken up, Lordship, because it is an anticipatory bail, Lordship. I'm praying for, Lordship, anticipatory bail interim protection, because, Lordship, the allegation so far, Lordship, that is a petitioner number 1.
Who dealt, dealt with the other petitioner's case? The other order, actually. As per him, 21 petitions matter has been disposed of. Car court of all are pending still. All other connected matters are taken by court number 3 only. All other
the co-accused regular bail matter is listing today before the court number 3, Lordship.
For 21 petitioners.
No, Lordship. Only for, Lordship, one petition that appearing that case also, Lordship. Now here it is for the anticipated bail for the other petitioners, Lordship, other accused person, Lordship. Out of 27,
So here,
only for 21, Lordship.
No, this petition is for 21 petitioners.
Or 21 petitioners. Now, Lordship, considering that things, Lordship, so far, Lordship, the special act is there, Lordship. That, Lordship, 9, 10, 11, Lordship, probably 11, which 11 will be applicable against this case. That is punishment is only 3 years, Lordship, and fine, Lordship. Now, Lordship, see the what
person died.
No, Lordship. One that person died. The villagers died, Lordship.
Because then in the village area, Lordship, these things are, people are scared
Yes,
of these things, Lordship.
Borba.
So that's the case that we call for, my lord, because there is allegation of my lord 126, my lord. It is my lord previous history by served upon my lord. And medical report will be in this. If the case that is already my lord available.
Case study is lying there,
Then
Lordship.
the lordship may fix it on Thursday, my lord.
So can it be on tomorrow or day after tomorrow, Lordship? In the meantime, some protection may be given,
Day
Lordship.
after tomorrow.
Day after tomorrow, my lord. Let the case that is called for, then my lord.
Let CDB call for list the matter on day after tomorrow. Day after tomorrow will be 20.
Or may it, Lordship, take it up along with Lordship BA 3326/24.
Senior bench, yes, related matter be open and we discuss.
In the meantime, some protection may be given, Lordship, because of the ladies are there, Lordship. Out of that, Lordship, can you see the Lordship 15 to they are on run, Lordship. Because of that magic, Lordship, people are scared in the village area. Lordship has known better than me, Lordship. These things,
If they
Lordship.
think that still black magic is there and if going to kill a person. then it
No,
will-
they because of
They're
out of
trying to
wrong,
kill the father
Lordship,
of the
out of
informant,
wrong
right?
treatment of this informant
No,
father,
no, no,
Lordship,
they are
the
trying to
villagers
kill
died,
that
Lordship.
father of the informant.
Yes, Lordship.
And that is a which
He
has
is
matter.
practicing, Lordship, black magic. For his treatment, Lordship,
Your
another villagers
submission.
died, Lordship.
Now you also believing that black magic is
No,
there?
Lordship, that villagers is scared of that, Lordship.
Yes, okay. Good.
Lordship fix it on 20 after tomorrow.
If
High level.
CD is available, then we will see.
Yes, Lordship. High level.
May I please, Your Lordship? FIR is page number 14, Your Lordship.
Yes, 1-4.
1 4, Your Lordship.
Yeah, yes. Yes, any submission?
Lordship, may I kindly peruse annexure 4, page number 25, Your Lordship. A bail petition was moved in that before the sessions court that has been rejected, Your Lordship. In that bail petition, the informant filed a petition. The accused person have filed a petition under so and so. The matter has been discussed between the informant victim and accused person, and the informant victim has no objection if the accused persons are granted bail by this honorable. Lordship, in this context, Your Lordship may kindly peruse page number 4, paragraph 3, Your Lordship, of this bail application. Your Lordship. Page number 4, paragraph 3, that may be perused. GD1T was there, Your Lordship, no allegation, and it has been filed after almost 1.5 years, Your Lordship, but precisely after 4 months, Your Lordship. And paragraph 3, page number 4, that may be perused. They are in love, Your Lordship, they are having relationships. Only on 15/2/2023, Your Lordship, husband found them in compromising position, and that is what, Your Lordship, and that is why she will also inform the matter before the sessions court, Your Lordship, London Sessions Court, regarding the bail application, Your Lordship. And the husband also filed a divorce petition where he has mentioned that everything, Your Lordship. And age of the informant is 23, and age of the victim is 35 years, Your Lordship. 12 years elder than the petitioner, Your Lordship. Having 2 children, Your Lordship. Everything is consensual, Your Lordship.
Now this petitioner is her husband, no?
She is 12 years elder than the accused.
So she got pregnant with the present petitioner.
No, Lordship. These are
Oh,
all
why this allegation is there?
exaggeration is there, Your Lordship, because husband compelled first to lodge this affair. When he discovered these things, found out, Your Lordship, suddenly he came out. Somehow he got the information suspecting because he is discovering not getting her in over the phone late at night. He is busy. After lodging this, he lodged a divorce case, Your Lordship, annexing this CR case, Your Lordship. Initially, it was filed as a CR case. Subsequently, the learned court transferred before the Algapur police station. Annexure 1, page number 13. That is how this affair has been registered. Allegation 1.5 year older than. Only thing in 15/2/2023, husband came without giving any information to wife, came from Mizoram and
Saw her in a compromising situation.
that is how. That is what I have reflected in paragraph 3 of the. That is exactly what happened.
Yes.
And annexure 4, Your Lordship. The intention is very much clear, Your Lordship. She herself filed a petition before the Learned Sessions Court. Clear. That may be inferred, Your Lordship. What exactly? This much.
For other petitioners. For
No,
other
no,
accused persons.
other accused already in bail. Petitioners, father, brother, Your Lordship, they are implicated only because she went there like all
No,
those
in
exercises.
this bail order was earlier bail order was passed in connection with the other accused person.
No, Lordship, include the petitioner, Your Lordship.
Then he is in bail now.
No, Lordship, this bail application has been rejected. Even after filing that annexure 4, Your Lordship, that they have compromised.
Considering the gravity of the offence.
Yes, Lordship. This is the observation.
It is said, my lord, she was raped. After that, my lord, she again gave money, Lordship, installment, my lord. That's part of it.
But Your Lordship, on 12/2, she said that when I have lost an GD entry, police arrested him and let him go.
That's a case that is proposed.
Okay, I may be protected, Your Lordship. 12 years older than me, and I have narrated. And even in the petition filed before the Learned Sessions Court, she has made it clear. That may be inferred, Your Lordship. Anything but not rape, Your Lordship.
No, Mr.
R.H. Chaudhary, Your Lordship.
Mr. R. Chaudhary, the counsel for the petition. So heard. Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and false and concocted allegations has been brought against him only to harass him. However, it is a fact that the present accused petitioner had a love relationship with the informant, and when her husband saw them in a compromising situation, he forced him to lodge the FIR. But the informant filed a petition before the learned trial court below while disposing the bail matter, stating that she has no objection if the accused petitioner is released on bail. But the petition was rejected by the learned court below, and hence the present petition has been filed by the petitioner. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of interim pre-arrest bail. Next paragraph, interim pre-arrest bail to be revoked, considering the submission made by so and so. Interim pre-arrest bail to allow credible on 20,000 with 1 unit of like amount to the satisfaction of the arresting authority. Okay, you will be under interim protection. Let the CDB call for on
1312, my lord.
13
1312.
3012
1312, my lord.
13
My lord.
1312 proceeding. And will appear before the IO within 7 days and will cooperate the
Lordship,
IO
10
in further
days, because
investigation of this case.
10 days may be given. Lordship,
Why?
Lordship, there is derailment in that train. Road connection is not good in Borakbeli.
Okay, within 10 days. 10 days credible. Okay.
Oblige.
May please, Your Lordship.
Yes.
Okay. 42 BNSS application, Lordship. The FIR Lordship find it phase 14, Lordship. 1 for Lordship. Vernacular FIR Lordship. May I read the FIR Lordship? Page number 14, Lordship. May I read the FIR Lordship? সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 29/10/2024 তাৰিখে পুৱতি নিশা প্ৰায় 2:15 বজাত এক গোপনীয়ভাৱে সংবাদ পোৱা যায় যে কিছুমান গৰু সৰবৰাহকাৰীয়ে অবৈধভাৱে ও চোৰাংভাৱে গৰু মেঘালয়লৈ সৰবৰাহ কৰি আছে। মতে সংবাদ পাই মাননীয় অচি মহোদয় মোক লগত ASI টিকেন চন্দ্ৰ ডেকা আৰু ষ্টাফসহ বিহিত ব্যৱস্থা ল'বৰ বাবে নিৰ্দেশ দিয়াত আমি গৈ টপাতলি মিলনপুৰৰ জংঘল এলেকাত নাকা চেকিং ডিউটি কৰোঁ। সেই সময়তে কেইজনমান লোকে কিছু গৰু খেদি পাহাৰৰ সৰু ৰাস্তাইদি নি আছিল। সেই সময়তে লোককেইজনে আমাক দেখা পাই পাহাৰৰ দিশে পলাই যায় আৰু আমি পাহাৰৰ এলেকাত ভালদৰে তালাচী কৰাত মুঠ 15টা গৰু উদ্ধাৰ হয়। উক্ত উদ্ধাৰকৃত গৰুসমূহ থানালৈ লৈ অনা হয়। পিছত জানিব পৰা যায় যে উক্ত গৰুসমূহ মেঘালয়লৈ নি কাছাৰীখানাত বিক্ৰী কৰাৰ উদ্দেশ্যে নি আছিল আৰু উক্ত গৰুসমূহ চুৰি কৰি অনা বুলি সন্দেহ হয়। The present petitioner lordships is the owner of the cattle lordships. I have annexed the cattle purchase receipt lordships. Your lordship will kindly see page number 19 onwards lordships. He has purchased the said cattle from Nokula Bazar, established under the Morigao Jilla Parikhad, the Gov registered market lordships. He is the owner of the said 15 numbers of cattle lordships. While the said cattle was kept in the said area lordship for the grazing purpose lordship. The police has seized the said cattle from the place lordship and seized the same lordship. And now the present petitioner lordship is the owner of the cattle lordship. I have annexed the all cattle purchase receipt lordship. My simple prayer for lordship is that he may be allowed to appear before the IO with these documents lordship, so that the documents can be verified by the IO lordship. Otherwise lordship, until and unless these documents verified, the investigation will not progress lordship. That's my humble prayer lordship. The police suspected that lordship this cattle is stolen one lordship. Page number 19 onwards, I have annexed all the cattle purchase receipt lordship.
Yes, brother.
My lord, lordship may kindly see the matter allegations made in the FIR. I am just not reading the entire my lord.
FIR is that page?
Page number 14, my lord. Vernacular.
Yes.
I am just reading the middle portion, my lord. এই সময়তে কেইজনমান লোকে কিছু গৰু খেদি পাহাৰৰ সৰু ৰাস্তাইদি নি আছিল। To avoid police, my lord, they are trying to transport the cattle, my lord, through hill area, my lord, to Meghalaya. And my lord, lordship will, my lord, my lord, in all the each and every cases, my lord, where cattle has been recovered and seized, my lord, they could not produce any documents, my lord. But when they file bail application or any other application, my lord, then they come with all the documents, my lord. That means, my lord, it is a stolen cattle, my lord, and documents are prepared, my lord, after the cattle were seized, my lord.
If this documents issued
That
from
is why, my lord.
Receipt are issued from the government market lordship. If it is a fake documents lordship,
Let the case diary call for, my lord, we will examine the case diary.
Otherwise, lordship,
after that, my lord, if necessary, he will appear before the IO, my lord.
No, until and unless this document is verified by the how the investigation will progress lordship. All the FIR lordship will see that Meghalaya, the cattle has been transferred to Meghalaya. This line is common lordship. Let him appear before the IO with these documents lordship. If the documents is fake, then I have nothing to say lordship. That's my humble prayer lordship. Otherwise, this
call for, my lord, if you find lordship that there is no material, my lord, then he may be allowed to appear before
otherwise,
the IO, my lord,
without these documents lordship, without this
because
documents,
each and every case lordship will find, my lord, they never produce any documents, my lord. When the my lord, it is seized from the car, my lord, in vehicle also, my lord, they are ought to, my lord, produce those documents before the, my lord, IO or the, my lord, police, my lord. But they could not produce.
The problem is that lordship, if the document is produced for the IO lordship, they always misplace the documents.
No, this is not.
Subsequently,
They can produce the Xerox copy also, my lord.
Yes, they have produced the let him appear with these documents. I can verify the document whether it is a genuine or fake.
My lord, this is for KPS, my lord. Lordship will fix it on Friday, my lord. Will produce the case diary.
Otherwise, lordship, until and unless these documents is produced, the IO cannot progress the investigation. Lordship.
That is our problem, my lord. That is none of his problem.
There is a fake lordship. Let him appear with these documents, lordship, so that the IO can verify these documents. No, not.
And apprehending of arrest.
That is true, lordship. He is not named.
They are trying to transport the cattle, my lord.
There is an allegation, lordship. There is an allegation. Otherwise, no offense will come in.
We have to go by the FIR only, my lord.
No. If that, let me
Friday
appear.
is call for the case diary. Friday will be 22nd. 22nd of this month. Call for the case diary.
Friday.
Okay, if it is there, then we may consider.
Yes.
Okay. I'm obliged. 30 also lordship similar, but there is no name in the FIR lordship. It was lordship FIR lordship kind of page 12 lordship. The type copy of the FIR lordship. The 4 numbers of accused person lordships, their rule is that they are just bokar lordships. Bokar in the sense lordship, they take the cattle from the owner lordship and they sell it to some higher prices lordship. Economic says that the cattle smuggler lawsuits. Page number 12, Lordship, you will kindly see. The present petitioner is no way connected with the present affair, Lordship. Page number 12. May I read, Lordship? With due respect, it is humbly stated that today on 16/10/2024 at about 8 p.m., as per the secret information, the IC came to know that vehicle bearing registration number so and so were carrying suspected stolen cattle from Nagar side towards Morrigaon. Accordingly, IC duly informed the OC of Mikibata PS, and the OC directed the IC to take legal action. Accordingly, IC sir, myself, UBC so and Nityananda Fukon, along with staff, went to Jaluguti, and during checking of vehicles at Jaluguti, the approached 3 vehicles were signaled to stop as suspected stolen cattle were seen, but all of them tried to flee away rashly. The vehicle being registration number so and so were successfully intercepted, and other 2 vehicles managed to flee away. Later, during search of the vehicle, 6 numbers of cattle were recovered from the vehicle. After interrogation, it came to know that the name of the driver is Mohammed so and so, and when the driver was asked to produce documents of cattle, he failed to produce any documents. Hence, the IC seized the cattle and vehicle in presence of the witness and brought them to the PP. It is mentioned here that earlier the vehicles were involved in the cattle smuggling. In this affair, Lordship, was stated in the affair, Lordship, the present petitioner is no way connected with the present affair, Lordship. No way connected.
Why he is apprehending?
They are apprehending because, Lordship, they are one forwarding report, Lordship, you kindly see. Forwarding report at page number, Lordship, 17, Lordship. They have put some name, Lordship. Page number 17, paragraph number, Lordship, 11, Lordship. The co-accused person, the main gang or leaders of the complete cattle smuggling racket, Zahirul Islam, number 2, Nur Alam, number 3, Shahjaharul Ali, number 4, Bapoti, number 5, Azad, number 6, Imran Hussain. One, Lordship, Nur Alam is there, Lordship. Nur Alam name is, Lordship, it is number 2, Lordship.
Sadarul is also there.
Sadarul, maybe Sadarul also there, Lordship.
Is there. Biruddin is there.
Sadarul also, Sadarul name is there also there, Lordship. But they have no connected with the present offense, Lordship. The rule is, Lordship, they are brokers as broker, Lordship, and they are broker in the sense, Lordship, they take the cattle from the owner, Lordship, and they sell it in the market on some higher price, Lordship. That is the rule, Lordship. Let them appear for the higher. I'm praying for the interim in this case, Lordship.
Is there same Friday you want, or?
No, Mother, this is from Mikibata, Mother. If Lordship, Mother, grants interim, Mother, then we'll fix it after 2 weeks. Otherwise, Mother, we'll fix it next Monday, Mother.
Interim ministers, their name has been uttered by the co-accused person.
Co-accused person, Mother. It's an organized crime,
It is not uttered, Lordship.
When the Mother police arrested some person, Mother, accused person,
Let-
they were interrogated, Mother.
I'm praying for interim in this
Mother,
case.
implicate some person.
Lordship.
Because these are all organized crimes.
I'm praying for interim in this case, Lordship.
These are the main gang leaders as per the version of the other co-accused
Are the
persons.
main gang leaders, Mother. Even the brokers also, Mother, they are also equally involved, Mother.
Market is run by the government itself, Lordship. They are taking revenue, Lordship.
Monday city car fixed. Monday. 85. Yes, 25. From Mikibata, 25.
I'm like Lordship.
31.
May I please, Your Lordship? Your Lordship, this is a 482 DNS's application. It's a charge sheet matter, Your Lordship. Your Lordship.
Already charged it.
Yes, Your Lordship.
Are you
Your
on?
Your
Are
Lordship.
you on interim and or no?
No, Your Lordship, there is one essential fact about this case that in the charge sheet also the police has mentioned that on the date of FIR as well as on the date of charge sheet, on these both dates I am abroad, I am out of the country, Your Lordship. An FIR is filed 49 days after the alleged date of occurrence, Your Lordship. Your Lordship,
No, it's
then we
okay.
have
Charged matter, we do not want to pass any order in that case. Let the petitioner file a petition, proper petition of bail, seeking bail before the trial court will.
Your Lordship, that was the matter when the earlier bail application was moved, AB number 1500/2020-24. In that we were under interim protection, Your Lordship. Thereafter, when the lower court records came, it was assumed that it was a matter under investigation and not charge sheet matter already. and therefore, your lordship, the final order was passed saying that we shall appear before the committing court, your lordship. However, the matter involved here is that, your lordship, the committing court is the court of the chief judicial magistrate, and the matter is exclusively triable by the district and sessions judge, your lordship. And therefore, we are ready to appear before the trial court and participate in the trial proceeding, your lordship.
And the Borwa, other two matters were disposed by the other courts.
Indeed, your lordship.
Then list before.
Indeed, your lordship, we have received summons, your lordship, from the committing court. Your lordship.
Other orders were also passed by the other benches, in fact. Better not to pass any. It is not passed by this court, this bench. Here's the next two orders here.
Yes.
It is before appropriate bench, I think. It will be two.
That also.
It is before appropriate bench. Any date you want?
Your lordship, the next date before the committing court is on 20th, so maybe fixed tomorrow or on 20th, your lordship. Or any interim order till the next date and be fixed before any court, your lordship.
Tomorrow, list tomorrow before appropriate bench.
Time being item 9.
A petition has been filed for recalling of the NBWs and PNA issued by the learned additional CGM Tinsukia, wherein trial has been going on before the 138 NI, your honor. Because of some miscommunication and health reason, I could not take part the proceeding, your honor. That is why on Annexure M page 39, first of all, the NBAW has been issued, and thereafter PNA has been issued, your honor. Annexure 40 and Annexure 41. And similar case, there are two cases been pending before the learned court below, and one case I have a similar situation. A recalling has been called for, and this honorable court, while disposing at the case in the motion stage, allow me to appear before the learned court below on 25th, your lordships, with support all the documents, though I have already substantial amount has been paid. Order to detection. A substantial amount has been paid because of some health reasons I could not take part, and there is a non-communication co-part with some council over there, your lordships. The same person, your lordships. There are two cases have been pending. So I may be allowed to appear before the learned court below on 25th, your lordship, to face the trial and to produce all the documents regarding my the amount has been already been paid, the receipts, your honor.
What is the case, in fact?
Lordship, there is a NBW has been issued on page 39, Annexure M. This NI has been proceeding, your lordship. Page 39. I have to pay amount of rupees 3,39,000 rupees. And due to some health reasons, I could not take part in proceeding to produce all the documents.
No, whatever may be the reason, now you are the PNA was issued against you.
PNA has been issued. Yes.
My humble submission, my lord, subject to correction, my lord. There are some Supreme Court rulings, my lord. With PNA issued, my lord, cannot judge, my lord.
I will appear.
Secondly, no, my lord. This is not a criminal petition, my lord. This is an anticipatory base because, my lord, PNA has been issued. And he is bailor, my lord. He could not, my lord, able to produce him before the court, my lord. That is why, my lord, initially NPW was issued, thereafter PNA issued, my lord. Now, my lord, whether, my lord, this court has jurisdiction or not, my lord, to pass this state protection, my lord.
No, I am not seeking anticipated petition. I have to appear before this honorable court below on 25th in view of the order passed by the learned court below this honorable court on 5th 11 in a similar case, and I will face the trial and produce the judgment, produce the receipts. If it is the already been matter, we will settle between the parties. That is the issues.
That's what he is saying, that otherwise he is seeking protection.
Lordship may, my lord, at the best, Lordship may, my lord, to keep in advance, my lord, the PNA for 2-3 days, my lord. Let him appear before the trial court, you will file, my lord, this is a application, my lord. Because my PNA cannot be set aside, my lord. His paying is that to set aside the PNA.
No, one thing
because
is
there is no other scope, my lord. This is why the PNA has been issued.
No, the thing is that I
Because
have
the bailer also failed to produce it.
Yes, bail also failed to produce money.
no, I will be giving a face bill. I will produce a face bill. The thing is that I may be allowed. No, I may
cannot
be.
say he'll produce, but the court will decide, my lord.
No, the court will
Whether
let-
face bail rule, but my lord will be available, should be put or my lord the earlier bail rule.
As per law, this honorable court has passed an order. As
You
per law,
cannot say, my lord, I'll press.
no, as per law, the learned court bill has disposed of my matter, and the direction has been given on to appear before the learned court bill on 25th. Till then, this NBWs and PNA should be kept in abeyance. That is my humble prayer. On 25th, I will appear and produce all the relevant materials before the learned court below. Then, and
25th of which month?
this month.
Here it is 25/10 only.
No, Lordship, kindly see the order dated 5/11, which I this honorable court who are passing a similar order. This against
Similar order will come later on.
Lordship.
Now, question is that in your case whether it is 25/10?
No.
25/11?
No. Your Lordship, kindly see the annexer.
Which is the next date? Just tell us.
No, the case has been already been kept in abeyance due to PNA has been issued because the notice has not been served to him till date, Your Honor. The notice PNA issued or any notice has not been issued in a proper way. That is why the case has been pending. The case has been at this stage of abeyance for report. So I may be allowed to go for appear before the honorable court
The
below.
order, the last order. Let's place the last order.
Last order, Your Honor.
Because you have placed it 2 orders here.
Yes.
At page number.
Kindly give for 39, page number 39.
Yes, we are on 39.
39 is NBW has been issued, Annexer M.
Yes.
21/5/2024. Because my application for
see, yes,
loss.
just say.
Then they have the page 40.
Just see, page number 31, one order was there wherein the date was fixed on 1/7.
Yes.
Next you have not annexed the order of 1/7.
Lordship.
However, on
Yes.
annexed of 1/7 you have not annexed.
Lordship.
Then 7/8 is annexed. 7/8 wherein next date was for 17/9. Therefore, after 17/9 it was fixed for SRN appearance on 25/10. Thereafter you have not annexed any order wherein this is kept in abeyance or we are not in position
Lordship,
to say anything.
Lordship, the thing is that in computer checkout, I've checked it. The matter has been since the PNA has been
Is
issued.
the order? That's what I'm saying.
Lordship.
Is the order?
Last
Whether your case is kept in abeyance.
kept in abeyance. Kept in abeyance, Your Honor.
You have not annexed the order. That's what I'm saying.
Lordship, I'm saying that
It is of 25/10 only. 25/10 has already gone. So next date, whether it is kept in abeyance, that has to be there, but produced there.
But I will place the on next date fix your lordship sport. But the thing is that maybe I may be allowed to on 25/11, though there is a other case has been dishonorable.
25/11 is fixed by the other bench. It's not. The question
No,
is that
no,
we
they
be
just-
directed to appear on 25. They have a fixed date.
Fix it. Because the thing is that this honorable court has given me a chance to place
Obviously,
the
place the order. Whether your case is still kept in abeyance or any order has been passed by the court below. We are not in a position
Then
to
your
say
lordship,
anything.
then on day before, on fix on Wednesday, I will produce that status of the case on Wednesday.
On Wednesday,
What
we are
is
listing
the-
it on Wednesday.
What is your lordship?
20.
Computer system में दिखा दीजिए। Computer।
List on 20. Okay, we are listing it on Wednesday.
Lordship.
Just list us.
Lordship.
Yes, already. Yes, yes. Last item. Supplementary. Where is the order? Again, criminal petition. What is it? I need a cold party.
Section 61 of the supplementary.
Challenging the order which, my lord, charges were framed against me, my lord, and the proceeding, my lord. FR at page number
Charge
4.
has already been framed against
Framed,
you.
my lord. Under 387, 294, and 353, my lord. So FR does not disclose any of the offense, my lord. FR at page
So
number 40.
you're for challenging the order of framing of charge.
My lord.
Where is the order?
Order is at page number 29, my lord.
29.
My lord.
Yes.
Charges
the
were,
order?
my lord, 387, 294, and 353, my lord.
Hmm.
So I am saying that, my lord, none of the section attracts, my lord.
Against you.
My lord. So kindly come to, my lord, page number 14, the FIR, my lord. To attract, my lord, 387 actual delivery has to be there, my lord. It is absent, my lord. Page number 14 is the FIR, my lord. I was working in a entry tax gate, my lord, Karbi Anglong entry tax gate, as a tax collector, my lord. And a track commercial vehicle came, my lord. It was carrying, my lord, belongings of a judicial officer, my lord.
Judicial officer?
My lord.
Ah.
It was carrying, my lord. But that truck does not belong to the judicial officer, my lord. Truck was commercial, my lord. And they are not, commercial vehicles are not exempted from paying tax, my lord. They have to pay, my lord. So kindly come to the FIR, my lord. May I read?
Yes.
We are writing to report an incident that happened yesterday night, that is so and so, at about so and so. We were with the district judge and additional district judge, Madam so and so, in the official car coming from Nogao to Diffu. Madam so and so recently was transferred to Karbi Anglong, and her furniture and belongings were in a truck ahead of us, truck number so and so. Around 9 p.m., we reached the entry tax gate at Borlangpar. The truck driver Mukund Das said that the people at the gate were demanding ₹1,000 for the truck to enter Karbi Anglong. He explained that truck only had furniture, not commercial goods, or goods means for sale, but they would not listen. We tried talking to them too, but they were rude and refused to let the truck pass without payment. Madam so-and-so introduced herself as a public servant and explained that the items were her personal belongings. The boys still demanded money and started threatening the truck driver. At that time, one of us, AB Constable so-and-so, called the police station.
I may not be able to take this matter. No? I'm not
Familiar,
in
my
a
lord.
position to take
Earlier
the
also this happened, my
matter.
lord.
Because it just frankly speaking,
My lord.
I have some personal problems.
My lord, I know.
So,
Earlier also this.
it's a similar order was there.
My lord. Then, my lord, any other bench, my lord?
Because we have some, I personally have
Yes,
some.
yes, my lord, I understand, my lord.
VST is ever directed to place the matter before any other appropriate bench without me.
Well, kindly a date may be fixed, my lord, because after.
May I please, Lordship? I want to make mention. Item number 34, my lord. This matter may be taken up in next week, my lord, as the engaged counsel has left the court for his personal difficulty.
My lord, actually, my lord, item
No, I am
34.
34.
I'm here for item number 3.
Mention করেছে।
I am for
I'm here for item number 3.
No, 34. I am mentioning for. 34, yes. May be taken up next week, my lord, any date.
My lord, he has, my lord, respondent wife, my lord, counsel respondent wife, he has, my lord, he was there, my lord, but unfortunately he has gone to the another place, my lord, personal difficulty, my lord, is there. But it may be fixed on next Monday, my lord, no objection. On Monday, petitioner husband, my lord. On next Monday, my lord. On Monday, next Monday, my lord.
Lordship, Mr. Amkhaler's special purpose, he is in court number 18, Lordship, and one matter is going on, serious matter. So matter may pass over for the time being, Lordship.
I am entitled to default bail because the 76 is behind the bar. And coordinate bench already granted bail similar cases as a default bail.
Yes, Lord. But I have no instruction. He is in court number
After some
18,
time.
Lordship. After some time. Yes. Lordship, one item, another item, item number 43, with the consent of the other side.
43.
43. The matter may be
This is also pertains to CBI.
CBI, Lordship. I am respondent. I have taken consent, Lordship, after 3 weeks, this matter.
And so, on behalf of Special PP CBI, pray for an adjournment. After 3 weeks?
Yes, sir.
List after 3 weeks.
Lift to oblige.
Why it was timely? Acha ji.
Wait, legal lordship.
Who asked for timely?
Lordship, so we please to come to page 16 of the application. But page 16, madam. May I read paragraph 8, madam?
Para 8.
8, madam. That on the other hand, the complainant discharged her matrimonial obligation with utmost care and sincerity, with the hope that the behavior of the accused persons towards her would change, and for the conjugal life to subsist, the complainant tolerated all the physical and mental harassment caused to her by the accused persons during her stay with the accused number 1 as his lawful wife. That the accused number 1 was serving as a field assistant in veterinary department and is presently posted at Kuaritol, Nogao. And the accused number 1 on 14/3/2024 was preparing certain documents relating to his service, which were required to be furnished at his office as he is about to retire on 31st March 2024. Whence the complainant suggested him to initiate for insertion of her in his service records as his wife, at which the accused number 1 turned furious and called upon accused number 2, who in collusion abused the complainant and stated that by no means her name would be inserted in the service record of the accused number 1, as it would entitle her to claim pension benefits incidental to the service of the accused number 1. The accused persons made the complainant to suffer extreme level of mental agony and even insisted her to commit suicide. That in such compelling circumstances, the complainant, in order to escape from physical and mental abuse and for the sake of her life, flee from the company of her husband. Now, lordships, the dispute, she is my wife. I am not denying it, my lord. My earlier wife died, and this is my second marriage. I am 60 years old, my lord. I have retired on 31st/3/2024, my lord. Now, she is after my retiral benefits, and this is the reason this complaint has been lost. I have not denied her lordships that I will not insert your name in the service records. I will get pension. After me, she will get the family pension. My children are married, my lord. That is not a dispute. She is after my retiral benefits, lordships. Therefore, she is wanting gratuity and other payments that I have received. And this is the reason she has lost this.
Under which section it is registered?
It has been registered under section 498A, lordships. And lordships, may be pleased to kindly note, my lord, that 498A being a cognizable offence, my lord. Now, lordships, may be pleased to come to once, lordships will read the, come to page 18 once, my lord. Paragraph 2, my lord, I am reading. That I have not lodged any FIR before the police regarding the contention of CR so and so. And in fact, when I approached the Golaghat police station on such and such date to lodge FIR, I was being suggested by police to approach the Honorable Court for appropriate relief. Now, lordship, in my most respectful submission, this being a cognizable offence, my lord, she has to not only approach the police, but after
exhausting the remedies, she has to even approach the superintendent of police under section 154(3) of the CRPC. After the remedies are exhausted under 154(1) and 154(3), lordships, it is then that she can come to the court. She cannot come to the court directly, lordships. Therefore, lordships,
So what is the stage of this case at present?
cognizance has been taken, my lord.
Cognizance has been
Yes, lordships. The order taking cognizance is at page 20, my lord. Petitioner number 2, my lord, is my son. I am living separately with my son. And apparently, lordship, there are no allegations against petitioner number 2 in the complaint application. But cognizance has been taken. Lordships, in my most respectful submissions, this is a case, lordships, where no application of mine has been exercised by the learned judicial magistrate, my lord, in exercise of his powers. And this is a case, lordships, in my most respectful submission, where first the complainant, it was incumbent on the complainant first to approach the police, then exhaust the remedy under section 154(3). It is only then, lordship, this complaint could have been filed. In this regard, lordships, I would like to rely on one.
Okay, interim relief?
Lordships will stay the complaint case, lordships,
Item
till the
number
next day.
24.
Only that much, my lord.
Item 24. You are Garudia.
Lordships.
Heard Mr. P.K. Garudia, counsel for the petition. State is a formal party. Or
Formal party.
Also heard Mr. M.P. Goswami, the learned additional PP, being on behalf of state respondent. This is a petition on section so-and-so, connection with so-and-so, the KDP. Issue notice, the respondent, private respondent number 2. Also call for the scanned copy of the case record. No formal notice is required to be served on so-and-so. The counsel for the petition on interim relief, on the interim, it is submitted by him that false and concocted allegations have been brought against him only to gain the pensionary benefit of the present petitioner. Petitioner number 1, who is admittedly the husband of the respondent number 2. More so, he submitted it without exhausting the other process, without exhausting the required procedure, especially the formalities of under section 154(3). 154(3) CRPC.
Lordships.
154(3) CRPC. The case has been lodged and cognizance has been taken by the learned trial court below without applying its judicial might, and accordingly prayed for stay of the further proceeding in respect of the petitioners till disposal of this so-and-so. Considering the submission so-and-so till next date of listing, for the list after 4 weeks. Okay, to stay up till next date of listing.
Lordships.
Take steps on the respondent number 2 immediately.
Lordships. Oblige, sir. Lordships, till the next date stays there, lordships. Yes, lordship. Oblige, sir.
Earlier, lordship, this case was registered by the CID. Thereafter, it was transferred to the CBI lordship. And today, all the cases are listed in court number 18, series of cases, bail applications. Now, here, lordship, I am praying for implement of the CBI as party respondent. Oh, yes, lordship. earlier state was.
Now the case has been.
Now
all
here,
the cases
Lordship,
transferred to CBI.
the petitioners, they are in behind the bar for more than 75 days. Yes, Lord. Yes, yes. Yes, Lordship. And in dear Lordship may pass an order directing the CBI to produce the case diary and fix the matter on 20th, Lordship. Because we are behind the bar for last more than 75 days. Lordship?
CBI.
CBI, Lordship. CBI. What was it? Yes. Maybe Lordship. Item 51 to 58. Impeding.
Lordship, I am T. Begum on behalf of Mr. M. Halal, CBI, Special PP CBI. We are going to appear, Lordship. Mr. M. Halal is going to appear.
Dear Lordship, more than 75 days they are in behind the bar, Lordship.
Lordship.
Yes. Within the course of the day, Lordship.
Copy the line. Copy the
Yes. Yes.
Case diary and Lordship may be pleased to fix it on 20th, Lordship.
Lordship, I cannot say. I have no.
Because more than 75 days they are behind the bar, Lordship.
Lordship, lots of cases are pending. Yes. Already listed.
Then, Lordship, can it be on 21, Lordship? Then?
After 1 week, Lordship.
No. Well, today other matters are hearing is going on, Lordship. Item number 51 to 58 in court number 18. Therefore, Lordship.
Lordship, some other day, Lordship. After 3 days.
Yes.
After 3 days.
After 3 days, okay.
After Friday.
Friday. Look, already I think in our case whether it is available or not, I have no information, Lordship. But item number 51 to 58, those cases are going on. I think, yes, available, no? Yes, Lord, available. Lordship, deeply obliged.
Item numbers 45, 46, and 47.
My lord, before start of my lord, my lord, one thing, my lord, that my lord, 3 medical reports is yet to be received, my lord. In this case, my lord, that is regarding death, my lord, I will notice there, my lord. It is to be cut, my lord. Yes, my lord. Yes. Case there is available, my lord. Other medical, there are lots of people injured, my lord. That it is a mob attack on, my lord, police personnel, my lord, on duty. And, my lord, the injury report of that 3, my lord, police personnel is yet to be received, my lord. That is from the, my lord, note of, my lord, dated, my lord, 8/11.
66 days. Today is 66 days. Lordship, all under Lordship 147 is 90 days. Other sections
Yes,
are
ma'am.
60
90
days.
days of-
One section is only, Lordship. Otherwise, there is a mob altercation, Lordship, between the administration and mob of near about 2,000 people, Lordship. There is altercation was there, Lordship. Nothing is to be.
My lord, my item 1 to 8, 66 days. Petition 1 to, my lord, this is 46. Bail petition 30, Alamin Ali, 46.
And 10 others.
And 10 others. 66 days. My lord.
66 days.
66 days, 1 to 8. And 9, my lord. 9, he has passed away inside the jail.
Petition number 9.
Petitioner number 9, he has been struck off now, but he passed away inside the, that's how badly they were injured. And petitioner number 10 to 11 is 56 days. 56 days. And some of them received bullet injuries. 2 people died there, my lord. There were minors who also received bullet injuries. And they were arrested from the hospital, and juvenile board granted them bail because of their injury, my lord. And they're so badly injured.
There's nothing to be recovered.
My lord. Yes. Yes, my lord. It is. Yes. Yes, ma'am. And it will come from, my lord, GMCH, my lord. Guwahati Medical College Hospital. Yes, medical report. Yes.
3 days back also they took time for medical report, my lord.
2 times.
They have already taken 2 times. They have taken time, my lord.
My lord, my lord. Yes. Yes. My lord. My lord. Yes, 3 more.
Only one section above 60 days, my lord.
Nothing to be recovered.
And that also, my lord, waging war against the country. What is
Lots
war, my
of
lord?
things were recovered from
What
the
is war?
place of occurrence. There's a long list.
Nothing to
And
be
there were 2,000 people according to the FIR, my lord.
There's a long list.
2,000 people. We are not responsible, my lord. Might be recovered. So what? (46 and 47), my lord.
I am for 45, Lord. 45, I am for.
At 21st, my lord.
This is from GMC. Lord.
GMC, my lord. 21st. Thursday.
21st, my lord. Well, 22nd, my lord. My lord.
Grateful, my lord.
62.
Lordship, with your Lordship's indulgence, a matter has been mentioned. No, that is all right, Lordship, but there is an interim order in my favor. So that has to be continued. I do not have any difficulty. 43, Lordship.
Supplementary list.
Commercial. No, it's a very FOXO matter.
Item 48.
My lord, my item was 63.
So one.
Sorry.
Lordship. Item number 48. Yes. Yes, my CD we have received. Yes, for 48. No. Yes. If it is within a week, if it is fixed, we can retain it back. If it is Yes, Monday. No.
Your Lordship, I humbly pray for Your Lordship to take the matter up to sometime, Your Lordship. To take the matter up to sometime, Your Lordship.
50.
Here also CD is there.
Yes, Lordship. Yes, Lordship. Yes.
City is not up to date, madam. Not up to date, madam. My lord, it has come out. We have received the case diary, my lord, on 21/10, my lord. But that order was passed on 24/10, my lord. So after that, my lord, they have not taken back the case diary, my lord. No, my lord, on 24/10, my lord, after the city was called from, my lord. My lord, after that, my lord, they have not taken back the case diary, my lord. Yes, my lord. Yes, my lord. My lord, we have informed them on 25/10, my lord, to collect the case diary, but my lord, they have not come, my lord.
Plus, POXO is there. POXO, Lordship, POXO is 15. POXO 15 is there. Lordship. Lordship, just take it. Just take it.
Service complete or something?
দেখানো অফিস নোটে দেখানো
Whether service complete or not, my lord.
Yes, Lordship. As per order, Lordship,
Can I get steps to can I get
to OC, concerned OC. Lordship.
They direct cannot take, my lord. They have to submit the steps to the registry, my lord. Registry global level. Huh?
Lordship.
Then, my lord, we have to verify from the OC, my lord. Lord, say fix it that, my lord. In the meantime, we will also call for the update case diary, my lord.
Hop.
9th of December, my lord.
Publish.
51 and 52.
My lord, 51, 52, we have not received the case diary, my lord. My lord, in this case, my lord, the case has been transferred to CBI, my lord.
So up-to-date case diary has not been. Yes, Lord.
CBI transfer করছে।
No, transfer করেছে, সেইটো আগৰ পৰা জানে। তাহাঁতে they have the knowledge.
My lord, CBI now. So, my lord, the matter will be listed again, my lord, showing the name of the CBI, my lord.
Also, CBI was appearing in this case, Lord, because we have served in copy. Also, yes, Lord. Already appeared. We have served a copy. Also, in the last day also it has appeared, Lord, along with Ranjit Kakoti's case, Lord. Ranjit Kakoti was granted bail on the last occasion, Lord. And these are AB matters, Lord. It has been reflected in the order there. Update case.
Last order was there.
Yes, Lord. Update
That
case
day-
diary has not been. Sought. Update case diary has been sought for from CBI. Lord. Last order.
Copy of the bail application be furnished to the Standing Council CBI.
So there has been furnished.
Already furnished.
Already
CBI
furnished.
by Learned Council is for now.
Order dated 4/11, Lordship.
4/11.
4/11.
4.
Yes, Lordship.
Twenty-three 10, 24 9, আকৌ 4/11, so উল্টা উল্টা। আচ্ছা।
Okay, it may be taken after some time. I will inform the council of CBI, Lordship.
Today most probably he is busy in court number 18, I think. I don't know the time. We can make it time being, but if you can inform, then inform it.
I will inform.
53.
এইটো 51 and 52 আছে, yeah? Time being করে দিছে।
Where is it? We have received the case diary.
Well, the vehicle was recovered in an abandoned position in the manner is for a come of my lord. And I am not the owner, my lord, not the driver, my lord. I have specifically stated one Raju Sanav is the driver, my lord. He is driving the vehicle. And while abandoned vehicle, some ganja was recovered. It's a huge quantity. I am not the owner, my lord, not the driver. My lord.
Not the owner, not the
Driver,
driver,
madam.
where from the contraband was recovered. Okay.
The vehicle was recovered in a abandoned position in a picnic spot of NSPC. The suspect there, I am driving the vehicle, according to. But I actually said one Raju Sanav was driving the car at that point of time.
You are not the driver.
No. The vehicle was registered in my father's name. madam. My father's name. That is why, my lord, even my police is not searching my father. My lord. They is my lord, searching me only. Yeah, please.
The vehicle number, my lord, A07W2885, my lord. Carrying, my lord, around 45.398 kilo of ganja, my lord. The accused prisoner, he was driving the vehicle, my lord. When he saw the police, my lord, he took the vehicle some other lane, my lord. Then police seized him, my lord. After going, my lord, some kilometer, my lord, he stopped the vehicle and he fled away, my lord. And there are sufficient materials, my lord. He was driving the vehicle, my lord. Even, my lord, his wife is implicated in, my lord. So this is not a fit case, my lord, to grant him, my lord, period as well.
Heard Mr. A. Khanika, the Learned Council for the petition. and also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. Listen application. CD received, where is received, hard received. It is submitted by Mr. Panika, the counsel for the petitioner, that he is innocent and he is no way connected in the alleged offence. Owner of the registered owner of the vehicle, nor he was driving the vehicle at the relevant point of time. As per you, who was driving the vehicle?
Raju Senapati.
One Raju Senapati was driving the vehicle at the time, and the vehicle was recovered in an abandoned condition. Father of the present petitioner is registered owner of the vehicle, and for that reason only the police is searching him and he is apprehending arrest. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest. Mr. Borba, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against the present accused petitioner. Rather, he was the person who was driving the vehicle at the relevant point of time, and seeing police, he fled away, leaving the vehicle there. And after, though he was chased by police.
He was chased by police,
He could not.
But he did not stop the vehicle after going some few kilometers. He stopped the vehicle, he left the he ran away.
Some distance, he stopped the vehicle and fled away from the place of occurrence. According to Mr. Borba, submitted that this is not at all a fit case wherein the present petitioner can be granted with the privilege of pre-arrest bail. During this submission made by the learned counsel for both sides, materials available in the case, the nature of allegation, I find that custody interrogation may be required for the proper investigation of this case, and hence I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. Rejected. Your petition stands rejected.
Deep
May it please your lordship.
Case that is similar.
482 of 482 application of BNSS under BNSS lordship. Here offense related to theft and relates to some road rule, broken of road rule policy, and 7 of EC Act. And lordship, 7 of EC Act is a bailable offense as per the judgment held by this honorable court. Lordship, before referring this FIR lordship, I like to place relevant documents of the petitioner, who is a rice trader lordship. He's running his business as Isha Traders, in the name of Isha Traders lordship. Is a prominent businessman lordship, and I have annexed all his business related documents. Starts from page 9 lordship. Lordship may peruse page 9 is the annexure, that is the trade license at page 9, Asian Traders. Then his firm has duly registered under Goods and Tax lordship, and Government of India has issued registration certificate to him, that is at page 10 lordship. And then his food and service tax identification number I have annexed lordship at page 11 lordship. And then lordship would be pleased to now lordship, what has happened lordship, this in course of his business dealing lordship, petitioner loaded 240 bags of rice lordship with the challan as required, as per requirement of the road challan lordship. He has sent this invoice lordship. I have annexed at page 15, annexure 4 lordship. That is the invoice issued by the Isha Traders. Along with this lordship, rice has been loaded, and it has been loaded to towards Shuman Enterprise Shillong lordship. So consignee and consignor's note both has been delivered to driver. Now what has happened, lordship would be pleased to find that at page 8 lordship. Page May I read the FIR, Lordship? This is to inform you that acting on a trip of, as per the order of OC Gorchu PS 31/10/2024 at about 1 so afternoon regarding illegal transportation of PDS rice from Barpeta district to Meghalaya. On the basis of this information, it was reduced in writing to Gorchu PS so. I, along with my staff, proceeded to Baragaon under Gorchu PS, set up a NACA at NH 27 Baragaon. Further, it is pertinent to mention here that source provided the track number bearing registration number so. During NACA checking, the said track was witnessed by me and my team, which was coming from Jalukbari area towards Gorchu in a very rash and negligence manner and hit on the police barricade, with an intention to hurt the police personnel on duty and obstructed the personnel in disbursing lawful duty. I somehow managed to detain the said truck and questioning the driver regarding the loaded goods. In questionnaire, he replied that the truck was loaded at Barpeta with bags of Ushna Chawal. Later on mere suspicion as empowered as per Section 10 of the Essential Commodities Act, I, along with my staff, searched the loaded truck and found that the truck was loaded with 200 packets of suspected PDS rice. Therefore, as per provision of BNSS and as per direction of OC Gorchu, PSI seized the truck bearing registration number so loaded with stolen PDS rice, detained its driver Muhammad Anwar Hussain on demand of the valid documents regarding the loaded rice. Driver said truck failed to provide any valid documents regarding loaded rice. Therefore, it is strongly suspected that the loaded rice may be stolen one. Now, Lordship, while registering this incident, this affair, Lordship, it was while loading in the road, while the truck was flying and it was about to go, the driver was handy with the documents because the owner is having three challans. One is for the driver for the vehicle, other is for the consignor whom to be delivered, and one for him. The one for him, that is I have annexed with my petition, Lordship. So the consignment was all valid, Lordship. Now this question of this PDS, on that particular day, whether any stock has been diverted from any stock, whether that has been reported, so that has not been disputed here. They suspect that it is stolen well, but I claim that even as I have filed a JIMA petition seeking the ownership of that is under consideration, Lordship. So my humble prayer at this stage, Lordship, I am the bona fide and I am the lawful owner of the rice. I want to cooperate with the investigation. I want to place, but since the other sections are not non-bailable, Lordship, I may be taken into custody. And as of now, all the sections are, Lordship, below 7 years. As per the mandate, Lordship, below 7 years punishment, Lordship, I have to furnish I should have furnish a copy of 35 notice, Lordship. That is the most important requirement, Lordship. As of now, they have not provided any such notice, Lordship. So I want to comply, Lordship, from my side, Lordship, as I have already sought for JIMA of the moment I will claim that will go to, so I'll be taken into custody. So for my protection, Lordship, I have appeared before this court. Even I am ready to place all these documents before, already given, but even I'm repeatedly, I'm ready to cooperate and place the same before the police station, Lordship.
The case that he reveals, my lord, the truck was stopped, my lord, and my lord, this rice bags were seized. And when my lord, the driver was questioned, my lord, it is said that he could not produce, my lord, any document, my lord. Now, my lord, as part of my lord, driver's statement, my lord, that the rice was loaded by the, my lord, owner of the truck, and my lord, this accused person, my lord. Whether, my lord, it is a stolen rice or not, my lord, that, my lord, he has to definitely have to show, my lord, some documents, my lord. If he could not produce any document, it is a stolen one, my lord.
I'll place my documents, Lordship.
I mean, you are the
I'm the
rice owner.
Yes, I'm the rice owner.
And this truck is also belong to you?
No, it's not belong to mine. It's a hired one. The truck was hired by me,
As per you,
Lordship.
the owner of the truck?
owner of the truck, my lord, as per driver's statement, my lord, owner of the truck and the owner of the rice, my lord, they have loaded the my lord, rice in their vehicle.
Owner of that truck is different person, Lordship. I'm only the owner of that rice, Lordship. And the dispute arose when the driver, Lordship, actually he hit the barricade. That was the situation.
But only, my lord, the stolen, my lord, that has been alleged to be stolen, my lord, and that has been entire, my lord, rice bag has been seized, my lord.
Already says, Lordship. So I'm ready to cooperate, Lordship.
Heard MST Som, the learned counsel for the petitioner, and also heard Mr. R.J. Borva, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, parents the same, 100%. It is submitted by MS. He is the rice owner of the. He is the rice owner which has been seized by police from which was loaded in a truck to transport it to Meghalaya, and Meghalaya first. He further submitted that the present accused petitioner is a rice trader having his business in the name and style of Ishan Traders, and his farm has already been registered, and the registered licenses are also issued in favor of the present petitioner. It is a fact that on the day of incident, the rice were loaded to transport it to Meghalaya. What is the consignee name of the consignor?
Suman Enterprise, Lordship.
Meghalaya to Suman Enterprise, the consignor, and the all the relevant documents were along with the present petitioner, and one set of the challan was also handed over to the driver. But it is the allegation brought against the driver that he could not produce any relevant documents at the time of seizure of the vehicle along with the loaded rice. She further submitted that he is ready and willing to cooperate the IO and will produce all the relevant documents before the IO if the petitioner is granted with the privilege of pre-arrest bail. Next, Mr.
Where lordship is disposing of, my lord.
Yes.
Let his statement, my lord.
Context, Mr. Purva, the learned additional PP, submitted that from the materials available in the case diary, it is seen that the driver could not produce any relevant documents, and on the basis of which it was suspected to be the stolen rice. However, however, there is no document before the investigating agency to hold as to whether the seized rice were stolen goods or it was duly loaded in the truck by the petitioner. Next para, considering the interest submission made by so and so, this court is of opinion that the petitioner may be given the interim may be granted with the interim pre-arrest bail so that he can appear and produce all the relevant documents before the investigating authority. Interim pre-arrest bail deliver. When the case there will be called for?
My lord, we'll fix it. Today is 18, my lord. So we'll fix it 10th of December, my lord.
You cooperate with the IO 7 days, within 7 days, appear before the IO and produce all the relevant documents.
Yes, I'm deeply obliged, Lordship. Deeply obliged.
My lord, I'm very sorry, my lord. Regarding item 62, my lord, we missed it, my lord. Also, kindly fix it in its shorter date and our appearance may be shown, my lord.
Otherwise, when it is fixed?
1 week, Lordship stated. Friday, Thursday or Friday, my lord, kindly, my lord.
Friday can be?
My lord.
Friday fixed. Item number?
62.
60?
62. 62.
62.
Highly obliged, my lord. Much. And showing the name of the amicus curiae, my lord. Showing the name of
Should be.
And showing the name of the amicus curiae, my lord. Amicus curiae has been appointed, my lord. Poxo matter, my lord. So already appointed, name not shown, my lord.
What record to say?
Cover this said on.
811 office notice. Already.
Otherwise, again, they may take time, my lord. That's why. I'm sorry, my lord, in between we are mentioning that. Office. 811 office note, my lord.
Dr. P. Agarwal is
Doctor.
one Dr. P. Agarwal. Office notice.
Reflected in the order sheet.
Order sheet, office note.
Office note, my lord. Dated
811.
811, my lord. Office note.
The registry is also directed to the registry is also directed to reflect the name of Dr. Pooja Agarwal, the amicus, for the respondent number 2.
Highly obliged, my lord. Much more.
For admission, item 33.
May please, Your Lordship. My lord, long pending matter since August 2023, my lord. Here, my lord, the petitioner was arrested along with his mobile phone. He was released by order of this honorable court. Then, my lord, his mobile was seized, not yet released. Then, my lord, he approached the SDGM Hosai, my lord, Judicial Magistrate First Class. Lord, she will kindly have a look at page 24 and Annexure 5. My lord,
Mr. Borwa, whether report is available?
Report not received, my lord.
my lord, my matter is pending since August 2024, my lord. My lord, there is my lord, a report only, my lord. They are not furnishing the report. My lord, the matter is pending since August 2023. Kaki Thana. My lord, there are so many judgments of Honorable Supreme Court, my lord. My lord, my petition should be disposed of at an early date, my lord. I have also one judgment, my lord. In the case of Sundar Bhai Ambala Desai, my lord, my humble prayer is that matter will be disposed of at this stage. How long they can carry forward, my lord, without not furnishing the reports, despite several orders of this court, my lord. Deliberately, my lord, deliberate negligence, my lord, willful negligence, my lord.
It is pending, Ms. Purna. Obviously, there are lots of orders are there, several orders there and several directions were there.
Yes, my lord. We have received the report, my lord. I have received the soft copy, my lord. My lord, this mobile has been sent for FSL, my lord. And due to non-receipt from the FSL, my lord, he could not, my lord.
That is the submission 1 year back, my lord.
No, my lord, that report we have received, my lord, on my lord, recently, my lord.
No, my lord. Lordship, kindly have a look at the past order, my lord. They're saying that submission, making that submission since long back, my lord.
No, because if it is not released from the FSL report, we cannot, my lord, release the mobile phone, my lord, or give custody of the mobile phone, my lord. It is in the FSL, my lord. I can give the, my lord, hard copy, my lord. We have received the soft copy, my lord. Yes, my lord. Yes. Due to non-receiving of the FSL report and exhibits, my lord, along with the FSL report and exhibit, mobile phone was also sent for FSL examination. The aforesaid mobile handset along with the SIM card would not be returned to the owner, my lord. Even lordship is direct. Even lordship.
Maybe in the month of April, May, or whatever. But till now,
Pass a necessary order, my lord, that if the FSL, if he received the mobile phone from the FSL department, my lord, then it can be handed over to the petitioner. I think this is the
FSL report was they waiting. The investigating authority is waiting for the FSL report. There has to be some reason.
mobile handset, my lord, along with the SIM. It was sent for FSL, my lord. The handset has been sent, but it is not received, my lord.
Open there. That's why it was FSL along with the. They need some the clarification from the FSL. But the question is that how long it will take time. It's pending since July 2023.
Dispose of the my lord matter by giving some direction, my lord. Otherwise, my lord, we also cannot do anything, my lord, because the report, as per the report, my lord, it is, my lord, lying in the FSL department, my lord.
It was on 21/2/2023, in fact, wherein it is co-observed that the learned additional PP shall obtain specific instructions from the IO as to whether it is possible to download the offending post appropriate certificate under 65B. Because there was an objectionable post, I think. That's why the mobile was sent for FSL.
My lord, whatever the post has been made, my lord, that has been admitted, my lord. And what more FSL scrutiny or examination is required, my lord? He has admitted that, yes, I have made this post. He will face the, yes, he has all. My lord, the post, whatever post has been made, my lord, you will find at page 19. He has not denied it, that he has not made it. Page 19, annexure 2.
This is the post which
Yes,
was
ma'am.
alleged to have been was given.
Yes, ma'am.
But where it is this statement that you have admitted that the
My lord-
post was sent by you
My
only.
lord, on para 4, my lord, in para 2 also.
Para 2?
Para 2 is relating to the statement of allegation. But para 4, my lord, we have
Whether
said-
there is any statement made by you
Yes.
that the post was from you only?
Yes.
Is there?
Para 4, my lord, yes.
Para 4.
Para 4. He has made statement. He has made a post, my lord, but he has his intention is that he has nothing to. He has made it without any intention to defame anyone. That is his statement, my lord. Para 4. He has no involvement in any such activity of defaming or insulting the great personalities as indicated. The petition never had an intention to insult any community. That means he has made the post. So that is, my lord, apparently, my lord, admitted fact, my lord. Post he has made, but he has not admitted that he has defamed anyone. And nothing has been, no person has been made in the post, my lord, by name.
That's not clear admission. In fact, section number 4 subsection.
There is no admission, my lord.
Admission, my lord, I have not defamed anyone. I have made indirectly, that is there, my lord. Direct statement is not there, but he has stated that I have not.
The FSL report only because the defamatory statement or post was there. It may hurt the sentiment of someone. So, if it is admitted by you that in that case, there may not be a requirement because 65B is also to be collected by the IO. But it cannot be held that you directly admitted the post.
There is no such direct statement, my lord. Only he has stated that he doesn't want to, my lord, defame anybody, my lord, or his intention was not to defame, my lord. That is why, my lord, that is why it was sent for FSL to ascertain, my lord, whether that post has been, my lord, it was published from his mobile phone or not, my lord, or uploaded from his mobile or not.
That is
for that purpose only, my mobile was probably seized, my lord.
My lord, indirectly that is admitted.
Of additional, then it can be. Otherwise, this cannot be taken into consideration considered as a admission directly.
My humble submission, lordship can dispose of the petition, my lord, only with the direction of the IO that, my lord, if the investigation is complete, my lord, so let the, my lord, mobile phone be handed over to him, my lord. Otherwise, I think, my lord, it is, my lord, only for pending for the FSL report, my lord. If lordship pass any direction, my lord, then, my lord, IO probably, my lord, inquire from the FSL department, my lord.
My lord,
for the release of the mobile handset.
Mobile phone handset. He is only paying for to, my lord, Zimma of the mobile handset, my lord.
My lord, why not, my lord, the IO can recover the mobile from the FSL? It is more than one year, my lord.
This is a, my lord, that observation may be made in the order.
Okay. We'll dispose of the matter.
My lord, I am relying on judgment, my lord. Paragraph 17, I have given the marks, my lord. That may be, my lord.
Regarding Zimma, my lord, our High Court has clear, my lord. During investigation, my lord, Zimma cannot be handed over.
Somehow we'll pass the order and dispose of the matter.
Developable.
This is 33. Nee?
35.
This matter has been listed at the instance of my friend, my lord. Because lordship, the trial has been held up. It's a maintenance case. I'm for the wife, he's for the husband. Trial has been held up and order has been passed. That you'll also kindly see. Order dated 11/12/23, almost a year now. So again, they have come against the initial maintenance of rupees 10,000. That was reduced to 5,000 in interim measure, and the whole trial has been held up. Second page also till returnable date only 5,000, 10,000 out of 10,000, and the trial has been held up.
May I propose
that is the problem.
May I propose something, my lord?
So we'll kindly see the order.
Lordship may dispose of the criminal petition, my lord, directing the my lord petitioner to pay 5,000 per month.
Why 5,000? 10,000 nowadays.
Till the disposal of the maintenance petition.
Not
Let the my lord, appropriate court, my lord, decide her entitlement. Yeah.
That your lordship will kindly see page 6.
I'm
page
praying that my
51.
lord, this petition may be disposed of, reducing the interim maintenance
How
amount, my lord. That has been already reduced.
That I have
Let the reduced amount be paid by the petitioner till the disposal of the my lord, proceeding.
No, he has come. I'm for the
I
wife.
have come.
He
I have
has
come.
come for that.
My lord. What the wife herself is an architect. My
But
lord.
she
She's
doesn't
an
have any income.
my lord, interior
Those
designer.
things are to come in the evidence. Now it's against interim they have come. After going through the assets and liabilities, the Lana trial court has passed the order of maintenance against the interim measure. That your lordship will kindly see page 51 annexure 6. The order that they have challenged.
that till the disposal of final disposal of the
5,000 I
petition.
don't agree. 5,000 is less. 50% or 10,000 was given. 5,000 is too less.
So let it be in between. Let it be 8,000. Let it be 8,000 in between. Because 10,000 it was granted. He is paying for 5. Let it be 8,000 till disposal.
My income, Lordship, may kindly see.
Income, he is having a mineral water plant. And he is saying that his income is 4,000.
Yes.
Whether it is believable nowadays. Even a rickshaw income is 20,000, 30,000 now.
Paragraph 70, I have mentioned, my lord. Paragraph
That
70.
is reflected in the order also. He is saying that his income is 4,880 and having a mineral water plant. Whether it is believable. The trial has not commenced. Amount is 55,000. 5,000.
Court has
Court has
given
granted
10,000.
After going through the assets and liabilities.
So at this stage, court will go through the assets and liabilities only. Though she is an architect, she is not having any income. That I've
It
said.
cannot be believed.
That will come in evidence.
In the beginner also.
She's quite an educated lady. I think.
Again, because she has submitted the assets and liabilities.
After going through that, the learned trial court has passed the order. That will come in evidence. Let them establish that I am having income.
Disposed of.
In that case, my lord, I'll have to take instruction from my husband.
In between, it should be always in
I'll
between.
take instruction from my
Why instruction is required for them?
Let me take up the matter after. Day after tomorrow. Day after tomorrow.
Day after tomorrow.
My lord. First.
Evidence yet to come.
Let them establish that I am having income. Then
See, that architect, my lord. Maybe
just because architect does, that is not believable. That is not believable. 4,880 in mineral plant. That's why. Also, can we fix the date?
that is also not believable that an architect is
Let
sitting idle.
them establish I don't have
That is
any
also
income.
not believable, my lord. An architect is sitting idle, my lord. He is an
Maybe
interior
sometimes
designer also,
even
my lord.
residents, they are sitting idle.
So I'll
Also,
take
can we
instruction
fix the
on that.
date?
Lawsuit will take up day after tomorrow, my lord.
35. Okay, we're listing it on day after tomorrow.
My lord. Obliged, my lord.
So 21, 11, 25. 21, 11 is not 20, 20. This one less.
Today is 18. 20.
36.
The similar cases. Lordship, here is the case wife was serving earlier, but she had to reject because of
After marriage.
36.
My lord, in this case, my lord, we have received one affidavit in opposition filed by them.
No, Lordship, this is not the way. 15,000 was granted by the trial court. Now, on an application under 438, whether 438 lies or not, 482. 430 does not interim order, no order lies against the interim order. The court has reduced the amount to 7,000. But lady's daughter is reading in the class 10. Her income is now 5,000. Her expenditure is 5,500.
Lord, explain, Lord. This is my case. I am the petitioner here, my lord. Lord, I have filed a petition, my lord, challenging the order giving interim maintenance of 15,000, my lord. Because, my lord, the liabilities that I have, my lord, that was not considered. And Supreme Court has been very categorical in the recent judgment that the liabilities have to be considered, my lord. In any case, my lord, on last occasion, they have filed an affidavit, my lord. There is very serious consequences has been happening, my lord. On 27/9/2024, they have filed an affidavit in opposition, wherein they say, my lord, the bank account, my lord, she has a bank account that was not disclosed in her affidavit in the assessable liabilities, my lord. That is admitted fact now. Now, my lord, I'm filing an application, my lord, where to initiate a proceeding under section 340 of the CRPC, my lord. That already this in the process, my lord. Today is being filed, my lord, and kindly give me some more time, my lord, so that it is on the record. Because she has admitted in her affidavit that she did not have any account in the assets and liabilities affidavit, my lord. In her own affidavit in opposition, my lord. Whereas from May onwards, the affidavit was filed in November 2023. She has admitted in her affidavit she has an account since May 2023, my lord.
is very crystal clear, my lord. So as per the enabling provisions of Rajneesh versus Neha, my lord, she has to be prosecuted, my lord, furnishing false evidence. That is why I pray before this honorable today, my lord, let the matter may be taken up next week, my lord. In this time, my lord, the IA it comes in the record, my lord.
Oh, you have received a copy of the.
Yes, I have received a copy of the affidavit. It's clear, crystal clear, my lord. She has admitted. She has annexed the copy of the SBI account, my lord, details, wherein it is very clearly stated the date of issue, my lord, 31/5/2023. And in her affidavit, my lord, kindly see I have annexed the hard affidavit of assets and liabilities at page 42, my lord. Kindly come to page 42 of my petition, my lord.
This is the statement made by
Yes,
her.
my lord. Clause number 9. Furnish copies of bank statement of all accounts for the last 3 years. NA, not available. This is a serious consequence.
All right. That serious consequence. On that day, at the time of filing of assets and liabilities, I did not have an account. Account was open in the year only 2023. So it is not necessary for me to file a 3 years.
No, this is your record.
No, all right. That is all right.
This
If
is
I have
your
committed,
record.
it is. I have committed. All right. I have committed. Now
No,
my
let
problem
me-
is that
let me file
my
a petition,
problem
my
is
lord.
that then the 15,000 was given interim maintenance. That 15,000 has been reduced to 7,000.
Yes, by
It's
intervention of this honorable court.
7,000 out of that only 7,000. The daughter's expense comes about 5,500. 1,500, 2 persons are living. He is drawing 65,000 his salary. Out of that, he has EMI. He has cut his EMI 15,000. That is not to be considered. So even if you take into account, doesn't have any liabilities. He doesn't have any dependent. Mother is not there. So at this case, it comes into one third proportion. So it comes about more than actually 15,000. It comes about 20,000. So my submission at this stage, till the matter is disposed of, the matter may be that interim maintenance may be enhanced to 10,000 at this stage. Because it is uncertainty. The lady is suffering. The daughter is suffering. Let the matter be decided. Okay, let it come as usual course. So let the matter be fixed. Let the interim maintenance be fixed for 10,000 rupees. It is very big amount. 7,000 is very, very big amount.
This honorable court has intervened in that matter. Already an order was passed. If he is aggrieved by that order, he has to go to a higher forum, my lord. Not like this, my lord.
No, 482. First of all, the 482 doesn't lie. Interim order.
That will be in the
482.
hearing.
What is the
That needs a
482?
hearing.
What is the 482 speaks about?
That needs a hearing.
What is the 482 speaks about? 482 has 3 conditions only. Now, under the banner of 482, where the matter is an interim maintenance is given, now he cannot refuse to give me the money. Maintenance amount. The minimum maintenance has to be maintained. 1,500 rupees is not enough for 2 persons to live on. So therefore, my submission at this stage, let the matter be heard after 1 year or till that time, at least 10,000 rupees should be given. It is not necessary that.
Yes, my lord. And if she has not come with clean hands, my lord, what
All
relief
right,
she will
I have
claim,
clean
my
hand,
lord?
come
She
with
cannot
our
claim
dirty
any
hand, we'll
relief.
see.
Let me file the petition. Let
We'll file the
petition
we'll
be
see
on the
that-
record, my lord.
We'll face the consequences.
Let the
We'll face
petition
the
be on
consequences.
record, my lord. I have filed a petition today, my lord, under section 3.
He got
praying
long,
for
but
an
he got
proceeding,
my
my lord,
reply.
under
Affidavit.
section 340.
He should have filed.
Let it be on record, my lord. First, that will be decided. Then, my lord, this thing will be hard, my lord.
At least, all right.
Next week, my lord. Any
I'm
day.
not
Next week.
admitting nothing at what the crime the daughter has done. Daughter should have been given.
Let us not
That
be
is why my
emotional here,
submission
my
at this stage is let the matter come up later on also. Till that time, 10,000 rupees should be fixed.
No, not like that, my lord. That's correct.
Maybe before the appropriate bench, you can. Otherwise, after 1 week, we are listing it.
Yes, my lord.
You are going to file the.
Yes, I, my lord. Yes.
Heard Mr.
R. Chakraborty.
R. Chakraborty, the counsel for the petition, and also heard Mr. B.K. Bhagavati, the counsel for the respondent. Case is listed in the admission column. However, it is submitted by Mr. Chakraborty. He had already received the affidavit in opposition filed by the respondent, and where there are some statement has been made by the respondent against against that, against and the against the said affidavit in opposition, he is going to file an interlocutory application within this week, and accordingly sought some more time, enabling the petitioner to file the appropriate application before this court within a week. Full stop. List matter. We want any fixed date here then in that case, because bail is
Next Monday, madam.
next Monday. Within Monday, you will be
Yes,
able
yes.
to. Let the matter be listed on Monday, that is on 25th, I think. 25.
Matter has been stayed before the learned trial court. Only thing that there are suffering, there is no evidence could not be led.
We are
Let the matter continue before the learned trial court.
So let the matter be decided first, my lord, by this.
It is.
honorable
It
court.
is.
He is making such kind of,
No, all right.
without hearing the matter, my lord.
I'm getting out of 15,000, I'm getting 7,000 only.
Yes, that is the, we've
The
been paying.
problem is that I got to lead my evidence also. I already filed my evidence on affidavit. Let them cross it. Let the matter proceed. Finally decided by the London trial court. So last 1 year it has been pending here before this honorable court. She is not getting the maintenance also, half maintenance,
No,
less
I've
than
been
half.
paying below
Less than half.
7,500.
Less than half she is getting. Even if that was not decided, in fact they wrongly submitted before the court and that order was obtained.
My lord, what kind of submission
right.
is this, my lord?
All right,
Wrongly
that was,
submitted.
it is that the
No,
person who is
let
suffering,
the
they
matter be
only,
heard, my
understand,
lord.
they only understand that difficulties before.
Let the matter be heard, my lord.
Till fixing it on 25, you file the interlocutory application, furnish the copy.
Yes, my lord.
Matter may be heard and finally decided on 25.
Always.
Trim maintenance only, I think.
Yes, it's only interment.
37.
May I please, Lordship? Would you kindly adjourn this matter, Lordship, and fixed first week of December, Lordship, first week of December.
This is the revision matter where NIA conviction was there, 6 months imprisonment, 8 lakh rupees fine. Conviction, they filed an appeal. Appeal was also dismissed and the judgment was upheld matter. Now they've come in revision matter. They have some difficulty with the matter. Date may be fixed matter.
Lordship,
Otherwise,
kindly
even matter is
first week of
pending for a
December,
long
Lordship,
time.
kindly fixed on first week of December.
Of December.
December, Lordship.
He is insisting for any fixed date.
Yes, Lordship.
5/12 we are fixing. And the request made by the non-counsel for the petitioner, let the matter be listed on 5/12.
Deeply.
Item 38.
My please, Lordship.
Yes.
Lordship, this is a criminal revision petition challenging the order of family court, Lordship, whereby I have been ordered to pay 12,000 per month, 7,000 for my wife and 5,000 for my children, Lordship.
What do you do?
Lordship, I am a CRPF employee, Lordship. CRPF, yes, Lordship.
CRPF?
Yes.
Achha.
CRPF employee, Lordship. So
now we are challenging the quantum only.
Yes, Lordship, quantum only, Lordship. So what happened in this case, Lordship? We got married in 2016, Lordship. After a stay of 2 years, in 2018, my wife deserted my house, Lordship. Then she filed a maintenance case before the family court, Lordship. And finally, in the year 2021, that is 3/11/2021, passed the final order. Then, Lordship, we have challenged the order before this honorable court, honorable high court, by filing a criminal revision petition. And then on that case, Lordship, this honorable court passed an interim order whereby directed to pay 6,000, Lordship. And again, on 3/10/2023, this honorable court passed an order whereby remanded back the matter to the learned family court to decide the quantum of maintenance afresh and directed to submit the assets and affidavit on assets and liabilities. Accordingly, Lordship, both the parties have submitted the assets and liabilities, Lordship. And after considering that, Lordship, on 31/5/2024, the learned family court again passed an order whereby directed to pay us 12,000 per month, Lordship. Here the contention is that, Lordship, the learned family court did not consider the assets and liability properly, Lordship. As per judgment of the Rajesh versus Neha, Lordship, the
both the party have to submit their bank statement, last 3 years bank statement, lordship. But in the affidavit and assets and liabilities of the my wife, lordship, she has not submitted that, lordship. That portion have been remain blank, lordship. Though, but she has a bank account, lordship. She concealed that matter, lordship, before the family court. And another thing, lordship, my father is a diabetic patient, lordship, and he needs continuous medication, lordship. That has not been considered, lordship. Another thing, lordship, my wife submitted the pay slip of 2022, lordship. That is, at that time I was posted in Jammu and Kashmir, lordship, the Union Territory of Jammu and Kashmir, lordship. At that time my salary was higher than now, lordship, and now I have been posted in the state of Jharkhand, lordship, where I'm drawing less salary than the state of Jammu and Kashmir. So my salary is changeable, lordship, as per the posting, lordship. So that has not been considered by the family court. That is why we are before this court, lordship. Yes, lordship. We are having salaries. She's with mother, lordship. I'm paying
one daughter.
Yes, one daughter.
How old she is?
She's 6 or 7 years, lordship.
So both for your wife and
children,
your daughter?
Yes,
12,000 was paid as a whole. In
12,000.
total.
Yes, no, 7,000 per month for my wife, lordship.
5 for your daughter.
Yes, 5 for my daughter. The page 65, lordship, that is 0.9, furnish copies of bank statement of all accounts for the last 3 years, and that portion remain blank, lordship. However, she has a bank account, lordship. He is in the State Bank of Koyakasi, lordship, Koyakasi branch, lordship. Now we are selling the, lordship, so far the maintenance of my wife, lordship. She's having BA degree, lordship. She's sitting idle, lordship. So she's not working willfully, lordship. The Learned Family Court did not consider the assets and liability, where there are many things the family court also have been considered, lordship. The degree of the parties, lordship, educational degree of the parties, lordship. But nothing have been considered, lordship. I have a father, lordship, so the father is dependent on me, lordship, and he needs continuous medication, lordship. I have annexed the medical certificate, lordship, page 99, lordship. Advice slip.
Have you furnished your pay slip at present? What is the salary you are getting now?
No, lordship, I have not submitted, lordship. But I have stated before in the assets and liability that my salary is changeable as per the posting, so that has not been considered.
Before, at the time of
filing assets and liabilities.
At the time of filing the assets and liabilities, so we have not furnished your pay slip.
I have stated, lordship, I'm drawing salary of 45,000, lordship, at that time.
Yes.
My lord, this case, my lord, he, my lord, receives, my lord, 66,000 per month, lordship. Yes, my lord, my lord.
As per him, at the relevant point of time, he was posted at Jammu and Kashmir, where it is the states are under risk, so that's why the salary was more than the present posting.
Yes, Lord.
The circumstances, section 127 is there, lordship. Section 127 CRPC is there, lordship.
not this is the proper forum.
Lordship, I have stated in the exception.
Now
liability,
kindly see Lordship, page 89, Lordship, the findings of the Honorable Court, Lordship, Court below, Lordship. Page 87, 89, Lordship, sorry. My Lord, paragraph 8. Married, Lordship. Accordingly, both the parties declared before this court, and on 4/11/2023, the first party filed her affidavit of disclosure of assets and liabilities before this court. But she alleged before this court that her advocate had represented the said document before her and asked her to put her signature thereon. She stated before this court that the said affidavit contains false statements and that the concerned advocate was pressurizing her to put her signatures thereon. She stated before this court that what is written in paragraph 3 of the column B of the said purported format of affidavit in page number 4, that is, she has received a total amount of rupees 2,88,000 as arrears of maintenance, is not a correct statement. Accordingly, notices were issued to the concerned advocate, Sri Musharraf Ali, and the notary public, Sri Ajit Kumar Sarkar, requiring each of them to show cause as to why appropriate penal proceedings should not be initiated against them. Both Sri Musharraf Ali and Sri Ajit Kumar Sarkar appeared before this court and submitted their respective written state explanations before this court. Subsequently, Sri Ajit Kumar Sarkar, Sri Musharraf Ali, and one Muhammad Rina Das, advocate, were examined on oaths as CW2, CW3, and CW1, respectively, pursuant to the inquiry under Section 340 of the CRPC. Eventually, and why this paragraph is required, my lord? He managed everyone, lordship, outside the court. When the advocate of the my lord wife, my lord, he has money power. My lord, I have nothing. I am my lord a woman folk. Eventually, on 22/3/2024, a 10-page detailed order was passed by my learned predecessor pursuant to the inquiry under Section 340 of CRPC, finding that the notary public Sri Ajit Kumar Sarkar and the advocate Sri Musharraf Ali were prima facie guilty of committing offences under Section 194, 197, 465, 467, 468 of IPC. My learned predecessor directed for instituting a formal complaint against them under his signature before the learned Chief Judicial Magistrate Borpeta for prosecuting against them, and both were directed to appear before the learned Chief Judicial Magistrate Borpeta on 22/4/2024. In view of the direction of the Honorable High Court, this court is only required to decide the quantum of maintenance afresh after taking into account the affidavits of disclosure of assets and liabilities submitted by both the parties. It may be mentioned here that the first party subsequently submitted her affidavit of disclosure of assets and liabilities on 16/11/2023, while the second party submitted his affidavit of disclosure of assets and liabilities on 23/2024. As per the affidavit of disclosure of assets and liabilities of the first party has no source of income. But as per affidavit of the disclosure of the assets and liabilities of the second party, the first party is doing tailoring work and earning rupees 10,000 in a month. However, the second party has not substantiated the above fact by submitting any document in that connection with his affidavit of disclosure of assets and liabilities. As per affidavit of disclosure of assets and liabilities of the second party is in government service in CRPF as constable cobbler, and his monthly income is rupees 45,316, including risk allowances, ration allowances, and dearness allowances. This is admitted, lordship. Now, but as per affidavit of disclosure of assets and liabilities of the first party, the second party receives a salary of rupees 66,759 as a central government service holder working as constable cobbler under Director General of CRPF. As a proof of his salary, the second party has annexed an attested sheet
attested sheet containing a table with names of 56 numbers of personnel from serial numbers 764 to 855 along with some particulars not specified therein. The name of second party is seen at serial number 817. In the last column against the name of the second party, the number 45316 is mentioned, which the second party claims to be his monthly salary. But there is no heading on the top of the last column describing the figures contained in the last column as to whether it is salary or something else. Moreover, there is no mention of the monthly year or to indicate for which month or year the said alleged salary 45316 pertains to. The said attested sheet thus does not substantiate the fact that the monthly salary of the second party is 45,316. On the other hand, with her affidavit of disclosure of assets and liabilities, the first party has annexed inter alia a copy of the payslip of the second party for the month of October 2022, as per which the gross salary is shown as 66,759 and the net salary as 61,819. Needless to say, the aforesaid document payslip is an appropriate document in support of the monthly salary of the second party. In his affidavit of disclosure of assets and liabilities, the second party has mentioned about his loan for an amount of 4 lakhs and about the ongoing payment of EMIs of 8,756 per month. But he has declared that the loan was borrowed from personal use, for personal use. That being the position, the borrowing of loan by him for his personal use cannot have any bearing on the quantum of maintenance allowance payable by him in favor of first party and her minor daughter. One more thing, which is seen from the documents, certificates of resident of 10 number Keotkosi Gao Panchayat accompanying the affidavit of disclosure of assets and liabilities of the first party is that the second party has entered second marriage by marrying with any woman named Saleh, by one woman named Saleha Begum. But in his affidavit of disclosure of assets and liabilities, the second party has not mentioned anything about his second marriage. Needless to say, the very fact that the second party has entered second marriage is indicative of fact that he has sufficient means to maintain the first party and her minor daughter, because if he had no sufficient means, he would not have entered into second marriage. Considering the affidavits of the disclosure of assets and liabilities of the parties, the standard of living of parties, the income of the second party, as mentioned above, the present day's cost of living and the escalation in the prices of essential commodities, I am of the view that maintenance allowance at the rate of rupees 7,000 per month for the first party and at the rate of rupees 5,000 per month for the minor daughter of the first party, as was directed in the judgment and order passed in this case on 3/11/2000 will be adequate, just and reasonable in the facts and circumstances of the instant case. Now, what I am submitting, Lordship, my lord, he is not with clean hands, Lordship. My lord, his second marriage is not disclosed. He is the employee. If he applies, my lord, he can, my lord, easily get, my lord, the salary slip, salary certificate. This is available also, online also, Lordship. My lord, that was not produced before the court below, Lordship. My lord, this is suppressed. He totally suppressed his income, Lordship. Only, my lord, the paper, my lord, having no headings, nothing, my lord, no authentication, my lord, that was submitted, my lord, names of some persons, my lord, that is not salary slip as per findings of the learned court below, Lordship. So it is his burden to, my lord, disprove that my salary is not so and so. My salary is this, my lord. On the other hand, my lord, wife has, my lord, produced the salary certificate. This is authenticated, my lord. As per that certificate, my lord, salary is more than 66,000, my lord, per month, Lordship. My lord, although he, my lord, admits he is 45,000, Lordship, to show lower salary, my lord. It is lesser than, my lord, the 66,000 lordship. That is also 45,000, my lord. Assume lordship, it is 45,000. Then, my lord, even then, my lord, 45,000, my lord, 25% of 45,000 is, my lord, around, my lord, 12,000 lordship. My lord, less than 12,000, my lord, like approximately lordship. My lord, it is not, my lord. This judgment is correct lordship. There is no fault. There is no fault with the judgment lordship. Only other, my lord, he is a man having manpower, my lord. He also managed my advocate lordship. It is finding of the land, it could be low lordship. My advocate, notary public, my lord, inquiry was there, lordship. What is going on, my lord? How, my lord, this person, my lord, can approach this honorable court, my lord? He has, my lord, done this, my lord, he is being a, my lord, responsible, my lord, employee of the central government lordship. My lord, even then, my lord, he is claiming, my lord, to reduce the, my lord, award lordship. This judgment is right. No problem is there, lordship. Even, my lord, 66,000, my lord, this is established lordship. This is proof lordship. As far as the judgment of the Honorable Supreme Court, should be, my lord, 25% of the, my lord, salary lordship. There is a judgment lordship. Then it goes to, my lord, 20,000 per month. Wife, my this is the judgment lordship. 25,000 of the income lordship. Income is not disputed. He has not disputed, lord. This my income. This he should have been disputed. Paragraph 15, lordship. Marriage law. Paragraph 15. The review petition under Order 47, Rule 1, CPC came to be filed by the respondent wife pursuant to the liberty granted by this court when the earlier Lordship lordship. Paragraph 15. My lord. The review petition under Order 47, Rule 1, CPC came to be filed by the respondent wife pursuant to the liberty granted by this court when the earlier order dated 2/2005 awarding a maintenance of ₹16,000 to the respondent wife as well as to her minor son was under silence before this court. As pointed out by the High Court in February 2015, the appellant husband was getting net salary of ₹63,842 after deduction of ₹24,000 on account of the appellant on account of GPF and ₹12,000 towards income tax. In February 2016, the net salary of the appellant is stated to be ₹95,527. Following Kulbhushan Kumar versus Raj Kumar's, in this case, it was held that the 25% of the husband's net salary would be just and proper to be awarded as maintenance to the respondent wife. The amount of permanent alimony, this is not relevant, lordship. Now 25,000, my lord, amount of 25% of the net salary, my lord, is proper and just, my lord, maintenance, lordship. That to the wife, lordship. Two persons, lordship. One is wife, another is the daughter, lordship. My lord, she is in school, my lord. 7 years, my lord. My lord, she is prosecuting studies, lordship. Now the cost of studies, my lord, nowadays it is very high, my lord. She is, my lord, daughter of a government employee, lordship, central government employee. She has a standard of, my lord, reading, my lord, in my lord, that is required to be considered. That is properly considered. But if it, my lord, I have not suggested her to, my lord, to file any, my lord, revision, my lord, or appeal, my lord, against the judgment, lordship. I suggested to be satisfied with this judgment. Even then, that is not given, lordship. By earlier judgment, my lord, 12,000 was given, lordship. Because, my lord, why the case was not remanded, lordship? Only, my lord, to submit to only giving to submit, my lord, giving opportunity to submit the my lord, asset liabilities affidavit, lordship. That was submitted. And learned court below has properly considered, lordship. There is no, my lord, wrong with this judgment.
Lordship,
And order of this court,
order of this court, Lordship.
page 48.
Page 50, Lordship.
48, page number 48.
Page 51, Lordship. I submit, Lordship. Lordship, so far the allegation of the Lordship that I have menaced everything, notary, public officer, and advocate of the opponent, Lordship. That is false, Lordship. There is no such allegation is there, Lordship. My wife, respondent here, she herself signed the affidavit on disclosure of affidavit assets and liabilities, and again she says that I have not signed that document, Lordship. Then that is the Musharraf Hussain is the advocate of the respondent, Lordship. He is not my advocate, Lordship. So there is no allegation again that I have menaced, Lordship. That is false, Lordship. And second thing, Lordship, the salary part, Lordship. So perhaps the learned court, advocate of the court, my advocate, Lordship, he could not understand the family court, Lordship, the salary portion, Lordship. There the family slip is there, Lordship. So this is the 2024 September, Lordship. And another thing, Lordship, the respondent wife, Lordship, she submitted her assets and liabilities on 16/11/2023, Lordship, and the pay slip which have been submitted of 2022 of October, Lordship. Why that is the Lordship? Because at that time I was posted in the state of Jammu and Kashmir to show the higher salary, Lordship. Only the pay slip of 2022 of October month have been submitted, Lordship. That is the fact, Lordship. And another thing, Lordship, in the affidavit on assets and liabilities, Lordship, my wife concealed the fact that she has a bank account, Lordship. Why she concealed, Lordship? Because she has amount, Lordship, in her account, Lordship. That is why she concealed, Lordship. She gave a personal loan, Lordship. I have received some papers, Lordship, and so obtained certified copy of the case, NI case, Lordship. She lent money, Lordship, personal loan. She has given personal loan to one Shahanur Haq, Lordship. And when she could not repay his loan, Lordship, my wife filed a NI case, Lordship, claiming that she lent money of 5 lakhs, Lordship. And she in her legal notice, Lordship, she is told that in paragraph 5, Lordship,
remanded back with an observation that to furnish the
assets and liability, yes,
so second time it cannot be remanded back. We have to dispose of the matter.
Yes, Lordship. So she
circumstances,
conceals the facts, Lordship.
Now we are not going on the fact now, so
yes,
it has to be here only. Anyway, yes, regarding the concealment of your bank statement, is there anything to say?
Yes, Lordship.
Bank statement, Lordship. That is not not under instruction, and that is not challenged, my lord, during my lord proceeding, Lordship. My lord, kindly his my lord seller. Why, my lord, he did not submit the my lord income tax return, Lordship? Why he, my lord, did not, my lord, submit the salary certificate, Lordship? It is his burden, Lordship. I have discharged my burden by my lord submitting my lord salary slip.
But the incomplete essential assets and liability, Lordship. Bank statement is vital, Lordship, in this point. On the Supreme Court is clear in this point, Lordship. Without considering the bank statement, Lordship, how a family court can consider the income of the respondent, Lordship?
I have stated I have no income, Lordship.
No income, then she ought to have submitted the bank statement before the family court, Lordship. That is the point, Lordship.
On that very ground, it can.
Maybe, Lordship.
Because on that count, it cannot be, Lordship. Only furnished, directed to punishment of assets liability. That is submitted, Lordship.
Lordship, if she can lend or of rupees 5 lakhs to other person, Lordship, then it is doubtable, Lordship, that she is not working, Lordship.
You are suppressing the income tax return. You are suppressing the salary certificate, your salary.
Say that suppression of the bank account is there. Apart from that, if she already lent 5 lakhs to someone else,
Yes, Lordship.
because of thing that he has also filed one NI Act cases,
Yes, Lordship.
then maybe the income or things may be there. So in that case, you have to bring all this to an additional affidavit. Otherwise, from your verbal submission,
I may be
it cannot be recorded.
I may be permitted to file an additional affidavit, Lordship, to bring on record
Because 5 lakhs, lending someone 5 lakhs, it's a questionable thing.
Yes, Lordship.
Otherwise, if a person doesn't have anything, any income, how can she lend 5 lakhs?
5
to
lakhs
someone?
to rupees.
Or is there any source?
Yes,
that has to be looked into.
I may be permitted, Lordship, to file an additional affidavit to bring on record these things, Lordship.
Disposal of the how much money you are getting from the petitioner side? As a monthly?
6,000, Lordship.
6,000 is getting Lordship. Other previous my lord, the balance is not paid Lordship.
Area amount is not paid.
Nothing
Lordship.
How I survive Lordship? My daughter, my lord, clears my lord more than my lord 10,000 per month Lordship.
Lordship, till now,
It's not possible to survive my lord. My lord, the intern may be vacated or my lord directed to pay 12,000 per month Lordship. It may be hard my lord in due course Lordship. Because I have to survive Lordship. You are getting salary 66,000 and you are maintaining other wife.
No, that is disputed. That is the only allegation. My respondent wife has submitted the Panchayat certificate, Lordship. Panchayat authority is not the authority to provide certificate, Lordship. And in this regard, Lordship, the petitioner has filed a case against the Panchayat or the president, Lordship, that she provide false certificate because the respondent wife has a good relation with that Panchayat president, Lordship. That is why she provide certificate, Lordship. And the Panchayat authority is not the proper authority to decide whether she is married or not, Lordship. That is a disputed fact,
Lordship, that does not bearing in this case, Lordship.
We are not.
It has no bearing in the case, my lord. You may file several hundreds of FIR, Lordship. You can file, you can lose, but it does not have any bearing because my lord, this is a question of fact that should be decided by the investigator by the IO, Lordship.
What to say? What do you want to say? Want to file any?
Lordship, additional evidence I want to file. There are many things, Lordship, in this legal notice and a complaint. There are many facts, Lordship. That
I thought after asset liability was submitted.
No, incomplete assets and liability, Lordship. There is
let him submit the income tax return and the salary certificate. Income tax return may be directed to the submit.
Mr. So-and-so, the council Anuddin was so-and-so, and also heard Mr. You are Mr. Islam, the council for the petitioner. Sorry, no petitioner, I have respondent. It is submitted by Mr. R. Islam, the counsel for the petitioner, that though the respondent had suppressed and did not disclose her bank account in spite of having her bank account, and from the instruction received from his client, it is also learned that she already lent money to some persons and also filed an NIACT case non-returning the money which she lent to one. Do you know the name person?
Yes, Lordship. Shahanur Haq.
To one Sahanur Haq. Accordingly, he submitted and he was to bring all this into the record by filing an additional affidavit. Mr. Ahmed submitted in this regard, the respondent submitted in this regard, that petitioner may also be directed to furnish his salary statement along with the income tax return, which he has already suppressed while submitting the assets and liabilities as per direction of this court. The petitioner is accordingly directed to furnish his present salary statement along with the income tax return to judge as to no. so and so. At least the matter accordingly. How many weeks you need? 1 week, 2 weeks?
But Lordship,
Because she is facing trouble. That's why.
Yes, Lord, that is the reason. So, Lordship, the petition is now currently posted in the system of Jharkhand.
No,
Lordship.
that cannot be accepted. You file
Lordship,
somehow.
Lordship then may authorize, his brother may authorize to sign.
That I cannot say. Anyhow, you have to submit because the respondent party is suffering because she has a daughter also, no? To maintain.
Only
And by
difficulty
that
is-
time, allegation is that you are also maintaining your second wife.
No, that is the allegation, Lordship.
Not allegation, these are findings of the court.
But Lordship, his only difficulty is that it is very difficult to get.
By you only. After 2 weeks?
That may be fixed also.
After 3 weeks, Lordship.
No, Lordship, then my lord may be, interim may be vacated, Lordship.
We are fixing it on 9/12. Ask him, file your addition, otherwise matter will be disposed of. Your verbal submission will not suffice. 9/12.
Deep law.
Against conviction, my lord. My lord, at this stage, appeal may be admitted, my lord, notice may be issued, my lord, and LCR may be called for, my lord. And another prayer, my lord, I have an IA, my lord, for bail, my lord. So a short date may be given, my lord, for consideration. 7 years, my lord. 7 years.
Do you want to file any objection here, Mr. Goswami? In I?
File.
Or one respondent is there, Manik Das.
Yes, my lord.
Notice may go.
Has to go.
Yes, ma'am.
Hard is to so and so. This is an appeal under Paki Bekidibo against the judgment and order so and so. Issue notice in the main appeal. Issue notice to the respondent. Number 2 through registered AD and oh no, this is a POXO matter. 376.
376, my lord.
Through jurisdictional OC. Routed to the office of the registry and the public prosecutor. Steps will be taken within 3 days. No formal notice is required to be served on so and so. Extra requisite copy may be served during the course of the day.
My lord, since it is an appeal, it may be admitted.
By the way, is there any proof of condoning delay, etc.? Is
No,
the
no,
time within
no,
time?
Within time, ma'am.
Appeal is admitted for hearing. Issue also call for the LCR. List accordingly after 4 weeks.
My lord,
In I also you issue notice. How since when he is in custody?
my lord, from the date of judgment, my lord, 26/7/2024, my lord.
I to same notice that I issue for you. In that context, Mr. Goswami Divo, the learned additional PP submitted that the state will file their objection. But without extra copies be served, but without the record, it may not be possible to file your objection also.
Difficult, but from the judgment we have to make it. Otherwise, from the loss.
List after 4 weeks. Both the matters. You take steps.
Date may be given.
Pardon?
Date may be given, my lord. Date.
It will come after 4 weeks because the record has to come. 4 weeks. Date cannot be given at this time.
Okay.
Made, sir. Appeal against conviction, Lordship. Sentenced to undergo imprisonment for 1 year. Is on bail, Lordship.
Bail. Why I is for?
I for suspension of sentence and allowing him to remain on previous bail. He is still on bail, 1 year sentence.
He is still on bail.
Bail. 1 year. Section 324. Minor or lacerated injury. Yes,
That's
I to look at it. I 980. The applicant and also heard Mr. M.P. Kusami, the learned additional PP, appearing on behalf of state respondent. And this is an application under
430.
430
430.
BNSS.
BNSS.
Under 430 of BNSS for suspension of sentence and till pending till disposal of the appeal and to allow the accused to remain on his previous bail. Submitted by Mr. Alam that the accused applicant was convicted by judgment and order dated 19/9/2024 in Sessions case number 4 of 2024. Appellant under section 324 of the IPC and sentenced to undergo SI for 1 year along with a fine of rupees 10,000 in default SI for 1 month. The petitioner is still in previous bail and during trial also he was on bail and never jumped over any condition of the bail. Mr. Kusami raised no objection in that regard. Next para, considering this submission made by the counsel for both sides. And the sentence, the judgment and the sentenced, by judgment and order dated 19/9/2024 in session case number so and so is hereby suspended till disposal of the pending appeal, connected appeal, and the accused is also allowed to remain on previous bail till disposal of the so and so. With above observation, the IS is disposed of. আপনি issue notice করে দিব main case of notice. In fact, the state is the only respondent. State is the only respondent. Issue no formal notice is required. Copy of the extra copy be served. Corridible. This is an appeal under 415 BNSS corridible against judgment order so and so. Admitted for hearing. Also called for the list accordingly after 4 weeks. I dispose corridible 8 to 4 days.
DP.
41.
May it please your lordship, this is an appeal against conviction under section 8 of POCSO and 354 IPC. I've been sentenced for 4 years. At this stage, notice may go minutes.
Respond number 2 is there. Respondent number 2 notice korai dibo heard so and so, it's an appeal so and so. No formal notice is required to be served kori dibo. We can also call for the case record. LCR also call for the LCR. And again, list accordingly after 4 weeks on receipt of the LCR. He is still in custody?
Yes, still in custody.
Later on, you can find any evidence.
Public.
Item 42.
May I please, Your Lordship? Here the petitioner, accused petitioner filed a criminal petition and accordingly the notice was issued and this honorable court state the operation of CR case number 611/2020-23 filed by the respondent, my lord, and accordingly the...
My lord, my submission is that they might not annex, they annexed one title suit, my lord, destination, case number 9/24. At the time of filing, we have not received this copy, my lord. So, my lord, let the matter may take another date. By this time, my lord.
Where is this maintenance of matter? It was most probably, I don't know.
Let the matter may be fixed on 1st of December. By this time, I will inquire into whether this notice is received or not, my lord. That restitution there.
They annexed it, my lord, but we have not received the summon or anything. I am the party, I am the respondent number 2 in this case, my lord. But in the title suit, yes, my lord.
Yes.
Yes, my lord. But we have not received this copy. That summon, my lord. Summon has not received, my lord. So in that case, yeah, they have not received, my lord. So we have to inquire into whether he will receive or not. So matter will be fixed on first week of December, my lord. By this time.
Whether they annexed a copy of the title suit, the petition? Is there any annexure?
They annexed it.
Yes, my lord.
In which page?
Annexure 40, case 41, my lord.
41.
41. The 9 of 2024 title suit. This is for restitution of conjugal right, my lord.
By this case, my lord, by this case, my lord, we have come across this fact that the case is filed.
But
No, but this is the restitution of conjugal rights.
this is a restitution of conjugal right. But the respondent sorry file a complaint case before the Court of Chief Judicial Magistrate Karimganj under section 498A and 498 323 506 to 342 34 IPC read with section 4 of the Dowry Prohibition Act of 1961 read with section 97 CRPC after 9 years of marriage, my lord. And she permanently used to reside her parents' house as she is working as a LP school teacher when she admitted her son in the Karimganj. Until date, my lord, after filing this complaint petition, the accused petitioner used to pay monthly expenditure to her. So where is the torture, mental and physical aspect? These are all fabricated, and her mother-in-law, the accused number 2, she is a aged about 72 years, retired school teacher, and she, from the day beginning of her marriage, she used to stay with her parents' house. So that is why let them.
We are denying all facts, my lord. Although the council of petition has submitted, we are denying all the facts. But however, my lord,
But
they filed this annexed this petition. So, my lord, we should inquire into whether at all they filed this case or not.
Yes, we have filed this case, my lord. There is a court
This is right.
order,
This is
my
my. We
lord.
have seen it. So I have to consult, take instruction from my client, my lord.
Let them take instruction, my
Matter
lord. Let
fixed
it be.
on first week of December, my lord. By this time,
Let it come after vacation, my lord, because during 1st December I have so many of matters in different courts. So
middle of December, my lord.
You want to say before vacation?
Before vacation.
Will it be a problem before vacation?
except 18-19, but interim orders shall continue, my lord.
Counsel for the petition. You are now Bujur Burwa or
A. Bujur Burwa.
Bujurwa, na?
Bujur Burwa.
MSA Bujur Burwa.
Alia Sharma.
So for the petition, and also had Mr. H.R. Chaudhary, the counsel respondent for the respondent number 2. It is submitted by Mr. Chaudhary that counsel for the respondent that they have annexed, the petitioner has annexed the one title suit bracket of restitution number 9 of 2024, but he has no instructions from his client as to whether any notice has been received in connection with the said title suit by his client. Accordingly, he submitted that some more time may be required to take instructions and to self-instruction accordingly instructions to stop. Next paragraph, considering this submission made by the learned counsel for the respondent, let the matter be listed. You want any fixed date?
Middle of December.
Mid of December. No, but she has some problem in 18 and 19.
Let it come
Before
after
vacation,
date.
only date.
After vacation.
Before vacation.
Before vacation. Let the matter be listed. No, 19 will be same problem. Before let it be matter be listed on any day. Fixed kori to kara.
16.
Yes, 16.
Obliged.
Only to file his, no, it's so and so quoted. How, till the next date of listing, interim shall be continued. Okay.
Yes, sir.
44.
May I please? This revision is directed against the order passing warrant of arrest against the accused, my lord. It's a pending case, my lord. Already there are 12 witnesses. Already 8 witnesses have been examined, my lord. What happened? The accused is from Manipur, my lord. Since the outbreak of the ethnic clashes from last year, it has become difficult for him to come regularly to attend the court, my lord. And therefore, what happened on the last occasion, my lord, that was on Annexer 3, my lord. It's order dated 16/2/2024.
Lordship.
State, my lord.
Only the state.
Yes.
Page number?
Page number 26, my lord. The second order.
26.
Yes, my
Ah.
lord. The accused
Yes.
is absent without steps. Issue bailable warrant of arrest through the SP Imphal West of Manipur. Fixed 27/3/2024 for appearance. What happened, my lord? The accused, he directed his advocate to take the steps on that particular day. But the advocate somehow forgot to take the steps. Then what he did, when the bailable warrant was issued against the accused, he should have informed the accused that warrant has been issued. On the very next day, that is on 27/3, without informing the accused, he filed a petition so order to rectify that earlier order, my lord. And that petition was rejected, my lord. You also may kindly turn to page 27. That is the order dated 27/3/24, my lord. He filed a petition without informing the accused that the warrant has been issued against him. Then again that petition has been rejected, my lord. Thereafter, notice was issued to the bailor, and subsequently what happened on 21/8/2024, the case has been filed and a non-bailable warrant has been issued against the accused, my lord. After that, my lordship, that advocate has informed the accused, my lord, that non-bailable warrant has been issued. Already, my lord, 8 witnesses have been examined. Only 4 witnesses are left. He will appear before the.
On the earlier occasion of the evidence, he was
Yes,
present.
my lord. Yes, he was regular. The case is pending from 2013, my lord. Since 13 to 2024, he was regularly appearing, my lord. Already 8 witnesses have been examined, my lord. Only 4 witnesses are left. He will appear and he will. You will also kindly allow him to remain on previous bail and let the remaining witnesses be examined, my lord. Cases sustained only against him under section 411 and 464. my lord.
Have
Yes.
you annexed any order sheet wherefrom we can have any, can be held that the case was fixed earlier for evidence or witnesses?
Yes,
were
my
being
lord. I will
present?
annex the search sheet also, my lord. Search sheet that annexed
Charge
to.
sheet is okay.
Yes, my lord.
Whether the case was pending for the evidence, whether any evidences were recorded, is there any statement or is there any?
I have,
things not here. I am not
I have
seeing.
stated in my petition, I have stated that the order has not been
Petition
annexed.
stating a petition is different thing. Whether we have received any case record is received.
Not received, my friend. It was called for, my lord. Kindly review the earlier orders.
Also, I have got the certificate copies of some of the statements of the witnesses, my lord.
No, it is nine definitely. The record was also. No, not before us also. Not the all the order sheets are also not.
Actually, this case has been should have been listed for motion, my lord.
Case order, madam, whether in the previous occasion, whether record called for or not.
No, last date we have taken time, my lord. Today it is
7/11, the first order was there.
That
And
we have
matter
taken
was
time.
adjourned only.
Yes, my lord. It should have been listed as motion, my lord, today.
And
I've
you
got
have
the
now
certificate-
say you have not annexed any
I've got the
the
copies
all
of
the order sheets apart from the copy of the witnesses. These are
I've
not
got the
here.
certificate copies of some of the statements, my lord.
You file, bring all this in the records, in fact.
Yes, madam. I'll file the
Otherwise,
affidavit.
there is nothing in the record. The order sheets are also not complete. 2, 3 order sheets are there.
Yes, ma'am.
And apart from this, But just we want to see that
Yes,
if
I'll
his
file an
presence was
affidavit.
there
Yes,
and the
madam. I'll
date
file an
record
affidavit.
was, I mean, the case was pending at the
Yes, ma'am.
evidence stage,
Yes.
then most probably there could have any order. You are Mr.
Our second.
R. Shekhar. Heard Mr. R. Shekhar, the learned counsel for the petitioner, also heard Mr. M. B. Goswami, so and so. Record it is seen that from the record it is seen that the LCR, no, sorry, it is seen that the LCR is not called for on the last occasion, and that apart, all the order sheets are not furnished along with the present petition. Neither the order sheets nor the evidence of the witnesses are being furnished along with the present petition. However, it is submitted by Mr. Shekhar, the counsel for the petitioner, that he has already obtained the certified copy of the witnesses who are already been examined by the court. Accordingly, the petitioner side is hereby asked to file an additional affidavit, bringing all the evidences, the evidence of the witnesses as well as all the order sheets on record. In the meantime, the LCR also be called for. Registry will do the needful. List accordingly when it can be listed for your convenience. Any date.
After 1 week?
After 1 week.
Let me after 2 weeks. Madam.
After 1 week, we may not reach the record may not reach. After 2 weeks,
yes, ma'am.
let the matter be listed after 2 weeks. In the meantime, you also file all
Yes,
this,
definitely.
bring in the record. I'm just returning you because all are certified copies. Yes. It will tell a copy detail. All this by filing an additional affidavit,
Yes,
it will be on record.
I'll file the downloaded copy of the earlier order.
Yes, earlier order also, because we are just nothing in the record as to whether.
Item 55 for orders.
Yes.
My file is with not me, Lordship. After 2 minutes, Lordship. Sir. A senior is outside, Lordship. My senior is outside, Lordship. After 2 minutes.
The CBA matter.
No, Lordship. No. Private matter. I said.
Sorry, my lord. It is been against Sheikh, my lord. A sank issued by the respondent, my lord, to me, and there was bounce. So, my lord, I filed my lord case, and that case was dismissed. So, against that, my lord. Actually, my lord, it has been listed at my instance. I made a mention to be listed in the court. That is, it is listed in the order column. It should be, my lord, first there is a, my lord, leave petition. And leave is to be first accepted, then, my lord, main appeal will be heard.
What's a leave petition? Is
Leave
there?
petition. Leave is required under section 478 of the CRPC. Against dismissal.
Against acquittal, Your Lordship. Against acquittal.
My petition was dismissed and his petition he was acquitted. So it is, I am against acquittal. Dismissal, yes.
They have filed a complaint case under section 138 of NIF, Lordship. In that case, they have failed to prove my legally enforceable debt. Accordingly, I was acquitted, Lordship. Against that acquittal, they have filed an appeal and they seeking leave to file appeal.
The petition?
No, Lordship, I will not file any objection. I will file objection, Lordship. Against the leave petition. And allow me to. I will file Lordship. 1 week maybe.
File objection.
Actually, in the trial court, my lord, there is no denial that he has not issued the check, nor my lord, denial against the signature. Both admitted, my lord. That means check and signature. If the check and signature are admitted, my lord, other things are automatically admitted.
But he is insisting that there was no legally enforceable debt against you.
That is the whole matter. So let
That is the finding of the trial.
So English that I have come here, my lord. So let them file an objection, then your lordship will hear.
Listen, until the leave is allowed, your petition, your appeal cannot be entertained. That's why.
Yes, your lordship, right.
I heard Mr. A. Rashid, the learned counsel for the petitioner, and also heard Mr. M. Rana, so and so, for the respondent number 2. It is submitted by Mr. Rana that they will file their objection against the present leave petition. Any weeks you need then, in fact?
1 week.
After 1 week, enabling the respondent to file their written objection against the present leave petition. List accordingly after 1 week.
Fixing a date, my lord, it will be.
Date fixing may not be possible after 1 week only. Lots of matters are already been fixed as well.
In item 56 and 57, my lord, it requires some hearing, my lord, because he has challenged. So, any date in this week, my lord.
Even lordship, on last occasion, lordship, I had completed my part, lordship. The honorable court was pleased before Honorable Justice Malshin Nandi. My part was completed and court was pleased to direct.
But there is no.
It is not reflected in the order, lordship. My friend was there, my learned senior friend was there also. And honorable court was of the view that, lordship, I have done my part.
Yes.
Yes, lordship. Yes. Let it be on Thursday, lordship, as because, lordship,
because Friday possible.
Then next Tuesday?
Maybe by Monday.
Tuesday?
Yeah, yes, it can be Tuesday also. Tuesday, but
as because, lordship, my bail petition is pending, lordship.
Everything is ready, I think.
Everything is ready, lordship.
Then it can be finally heard. Why on bail?
Sir, it will take. Otherwise, lordship, if it can be heard,
go by the merit of the case or the evidences of the witnesses, etc., is to be decided or discussed. In that case, better to hear the entire matter. Since when he is in custody?
Since last 3 years, lordship.
Since last, it is a 302?
No, lordship. 22C, lordship.
22C.
22C. 7 accused persons were there. 5 acquitted.
2 are there convicted.
Out of those 2, lordship, bail petition of 1 has been granted, lordship, on the ground that section 42 of the NDPS Act have been violated, lordship. He is on bail, and now he is the last one, lordship. And lordship, on the last occasion I had completed, honorable court was of the view that as to whether any violation of section 42 is there or not.
No, but it is not a part heard matter.
Yes, lordship. Not a part heard, lordship.
Now see, it is not a part heard, so it
Yes,
cannot
sir.
be fixed.
Yes, sir.
And you have repeatedly submitting that your part is, you have already completed your part. Most probably some noting is also been done by the concerned court. Bench. So at best we can enlist it after 1 week. In that case, if you make a mention before a raised date to list the matter before the court, where no, that may be one of the part.
Yes.
Otherwise, we have to hear the entire matter afresh.
Also not a regular bench now, 18, because they saying civil matters. So
think
if
civil
it is parted, without parted, it might not be listed. It will come to this. Any
Yes,
way, my
Lordship,
lord, we can.
I don't have any objection, Lordship. Lordship may
Next
hear
week, my
this
lord,
matter,
lordship may fix.
Tuesday, Lordship. Tuesday, Lordship.
We're listing it on Tuesday.
Tuesday.
List on Tuesday.
Highly applies.
Tuesday is 26.
Highly applies.
It is a lordship. Lordship, as per the office note dated 14/11/24, unserved registered notice in respect of the respondent number 2 is returned back without postal remark. I have we have taken steps to jurisdiction and police station, my lord, but
Can you just inquire what is happening? In fact, jurisdictional police station, was there any order of that kind?
yes, lordship.
Will inquire. POXO nahi hai.
Case of what? POXO?
No, my lord.
Then?
Is a criminal petition, my lord, against an order passed.
Criminal petition. Acha,
Criminal,
acha.
yes, lordship.
It's a criminal petition.
Criminal. Registered post. Otherwise,
You have taken steps by registered post also.
Yes.
You have taken now at presently you are taking steps by through registered post or through jurisdictional police station.
Lordship, earlier we have taken steps to registered post, lordship.
Okay, that was returned.
That was returned unserved, lordship. We may take fresh steps if your lordships direct.
No. As per 1411, just we have pointed out. This was taken most probably through registered post. There is a postal remark in question.
Yes, lordship.
So try it through jurisdictional police station this time.
Lordship.
Because it's a quashing.
It's a quashing of an order. Yes.
Of an order.
Yes, lordship. Interlocutor. Till then, my lord, the interim order may kindly be continued.
So pending at the even PW10, PW11, all these have been examined.
Yes,
so what is the stage of the case at present?
Lordship, it is in the stage of defense witness. Witness.
Oh, then petition may not be considered or may not be entertained also. Anyway, we're not discussing anything. Now we have issue notice corridible. As per office note dated 11/12/2024, the notice returned unserved issued against the respondent number 2. Accordingly, the petitioner is hereby asked to take fresh steps on the respondent number 2 through jurisdictional police station. Through the jurisdictional police station. Let the matter be accordingly listed. Defense.
Lordship, I have no instructions regarding that.
Date regarding date, you don't have any instructions.
No, Lordship.
Minimum 2 weeks will be required.
After 2 weeks.
After 2 weeks.
After 2 weeks.
After 2 weeks. List accordingly after 2 weeks. Take steps immediately.
Lordship, interim may kindly be continued.
Interim was there?
Yes, Lordship.
In which
There is
date
a stay
interim
of
was
the
there?
proceedings. Stay. There is a stay of the proceeding.
Where is the order?
Order, Lordship, may kindly see the
Yes,
order.
yes, 23.
23, yes, Lordship.
Interim be continued till next date of listing.
Obliged, Lordship.
May I please your lordship. Lordship, as per the office note dated 8/11, lordship, the steps was taken upon the respondent number 2, which was unserved, lordship.
You're saying as per 8/11 or 14/11?
14/11, lordship. 14.
Notice return through district magistrate.
Lordship.
Yes, sir.
So is it a proper address?
Lordship. Because the
Hattigao police station.
Lordship. The informant was posted there, Lordship.
Oh, he was an SI.
SI Lordship.
Oh, then why it is not served?
Maybe he has been transferred, Lordship, from that Hattigao police station. Probably, Lordship. So,
Because he is an SI.
SI.
Lordship. Proper address has to be collected by the petitioner, my lord, because
Do you have any instruction that he has already been transferred from Hattigao?
Lordship, not yet, but we have to take instruction, Lordship. SK Sarkar. 59, Lordship.
Right, the counsel for the petitioner. I also heard Mr. MP Goswami, the learned additional PP. As per office note dated 14/11/2024, the notice returned unserved on the respondent number 2. In that context, Mr. Sarkar submitted that the notice was issued on his place of posting at Hattigao, but he has no instruction as to whether he is still posted in Hattigao or has been transferred posted. Accordingly, the petitioner is hereby asked to take fresh steps on the respondent number 2 by collecting his present place of posting and the address, proper address and present place of posting.
Through registered post, Lordship.
Registered post করে দিব list accordingly after 4 weeks. Case diary was also called for.
Call for, Lordship.
Is it? Have you received the case for scan copy? Not received. Scan copy of the.
was perhaps the record, my lord, because the list shows that with LCR 3 files, my lord.
Yes.
Lordship.
Sit. List accordingly. Okay.
Hi, Lord.
63.
Please, Lordship, matter has been listed on my initiative, my lord, to consider the my lord, my lord, for staying the proceeding, my lord, the in order, my lord, and consider for bail, my lord.
May not be possible
My
today
lord,
to
my
hear the
lord,
matter.
I understand, my lord, my time is over, of course. Thank
But I have seen you. We have waited for long,
My
but
lord,
may not be possible. You're for the other side, respondent.
Maybe, my lord, 26, my lord. Tuesday.
26.
Tuesday.
Tuesday.
26 to need 27 দিব
6, let it be on 27 because 26 some matters are already been fixed.
My lord, my lord.
Remind the court
My
that then it can be heard.
My lord,
Otherwise,
my lord, my lord.
due to paucity of time, the matter could not be heard. List it on 27. 27. We're listing it on 27.
My lord. I love this man.
64.
May it please your lordship. Lordship, in this case, this IA was filed for the canonizing the delay of 238 days, lordship. We have taken steps upon the respondent, but the service upon respondent is still awaited, lordship, as per the last office note.
I mean, the address is proper.
The address is
Or-
okay. The service upon respondent is awaited.
No, I waited.
Okay.
Asking you whether the address in which it was sent is a proper address or present
Yes.
address is something else.
No, this
Srimati Anjana Das.
Yes, lordship. We have not received any instruction from the client that whether there is any change of address regarding the respondent.
Borabari, PO, Patila Doha. The address of the Petty petitioner is Philish Pushlaguri. So either to take fresh step or to await it. What to do?
Let's await lordship.
We are going to await.
Await.
Service and respond number. Her strengths.
A Bora.
A Bora. If state is also formal party here? No. Also her Mr.
64.
64 state is not a
State
party.
is not a party. Her so and so. From the office note dated 2/11. No. Sorry, 16/11. 16/11 so and so. This 16/11.
Lordship. Last office note.
Yes, 16/11. The service is still awaited for respond number 2. Let the service be awaited till next date of listing. List accordingly after 2 weeks. We have after 2 weeks. If it is not served, then you have to take fresh steps or say if you can any other address. Huh? After 2 weeks, it will be listed. In the meantime, if it returns, then it's okay.
Much obliged.
List is over. Timing matters were Mr. Halloy, the timing matters were there, but I'm not going to hear the matter now. So he was in item number 3, most probably. Yes, he was appearing. So you were busy in other court. I have heard already. Now 3 is for a bail. And he is submitting that he is already behind the bars since last 76 days. So that is his submission. And your matter was in
51 and 52.
This is also connected to CBI only.
CBI.
Let all the matter be listed again on 22nd lordship.
Because
Because mandatory period is
21 lordship.
21 lordship, possibly not. Let it be on 22 lordship.
Second, these 3 matters. Now,
Lordship.
can be listed or Monday can be whenever you want. Monday it will be late for him, I think.
My
And the
no,
huge
no,
scam lordship, financial scam.
no, I am
huge financial
submitting that
scam.
I want default bail because
Default
ordinary bail
is-
is already granted because case is
One of
registered under
the-
IPC. IPC already repeat, your lordship knows.
I
It is not
satisfy your
exist.
lordship that order has been passed wrongly.
What?
On Monday, I'll satisfy your
My
lordship.
director also
How that
present in
order has
that
been
case.
passed.
It may come on 22 lordship. It will be better.
How that order has been passed and satisfy whether 409 is applicable in this case or not. I'll
No,
satisfy your
no.
lordship.
409 is in my
That
case
is their submission. Yes, yes, yes.
in
Division bench judgment is there. From if your lordship sees the record, when 409 lordship criminal breach of trust by public servant, agent, merchant, and there are certain categories. So breach of trust cannot be done only one day, single part, on single day. First entrustment has to be there, and then lordship it has to be converted to own use. Yes, entrustment is prior to the coming on force of this Act 1/7/2022, 24. DNS has been come into force on 1/7/24. Now their stand is that 409 is not applicable as because the offense took place after 1/7/24. I'll show on that is just there.
case
I'll
is
show on
registered
record.
390.
I'll show on record that the offense entrustment is there prior to 1/7/24. I'll show on record. That order has been passed wrongly, lordship, erroneous consideration, lordship. And there is a division bench judgment of this honorable court which states that IPC offence is applicable even after the coming into force of DNS.
It is still applicable even after, but yes, the offense has to be committed. That is the main issue. If that is there, it's okay. If it is just that is not there, his submission may be correct also. So all the matters in 22nd or 25th as per you.
22nd.
22nd.
Only 76.
3 matters to Jikita ase, time being 21, 25. We are listing it due to paucity of time. Those could not be heard. List 22nd Friday.
Your lordship, item 49 you also put. Okay. 49.
49 is also CBI matter.
Not bail matter.
49. How can I get technical little? Oh, it has to be then 20. In just a second, 20, 40, 49 we have received. They were not present, but we have received the case diary here. No, item number 49, I'm saying. Case diary received. Oh, you have submitted that it cannot be retained more than 1 week. So within a week, it has been fixed. We have received the case diary. It will be retained till next date of listing. That to another 49 is timely.
Yes, same, yes, well, maybe it can be taken up within this week. This is convenient for lordship, otherwise some matters are fixed, my lord. Your next week, my lord.
By Monday or by Monday?
Lordship, there is interim, Your Lordship.
Interim is there. My Monday to fix 49 to due to procedural time, matter could not be heard. Fix on Monday. CD received. Retain this CD till next date of listing. Interim shall be continued till next date of listing. So your interim will be continued. We are listing it on Monday.